of the Marval International Summit on Compliance, Anti-Corruption, and Investigations. And please welcome Santiago Carregal, Chairman of Marval.
Buenos días.
Good morning. It is a pleasure here to welcome you to the 7th Summit on Compliance, Anti-Corruption and Investigation, which we have organized since 2018. We thank everyone for being here and whoever is watching on LinkedIn and other platforms. This year we have 22 experts, world-renowned, who have agreed to share their experiences on this subject. And we have speakers that are professionals from different sectors: fintech, pharma, consultancy firms, etc. And we thank you for being here in this conference. The change of government has brought new goals and objectives and priorities to our country, and we need to reflect on the role of transparency policies and prevention in a constantly evolving context. We have a lot to do when it comes to positioning Argentina in the Corruption Perception Index. We cannot want to go back into the world if we don't improve our performance in this issue. Argentina is trying to get investments and to come into the OECD. This must be a priority. We need to be completely committed, both in the public and the private sector, with this. Public governance, the integrity, and anti-corruption is one of the 5 most important subjects that will be technically evaluated to be able to go into the OECD. As the General Secretary Matthias Cormann said, who was last week in Argentina, we cannot change the past, but we can certainly work towards a better future. All of this seems ideal to understand the key issues for the new administration, which is the Minister of Justice, the head of the UIF, and the head of the promotion of privacy when it comes to the new administration and their goals. Thank you for being here with us. The implementation of the new penal code that introduces significant changes when it comes to judicial processes will have an effect on internal investigations, on spontaneous reports, and in collaboration and agreements. All of this regulation, when it comes to terrorism financing and money laundering, has gone towards a more dynamic path. On the other hand, new technologies are still evolving and they're changing everything. AI and the analysis of big data, the tools that we have available today allow us to see risk management in a different way. And they also challenge us both ethically and in safety terms. And AI can also transform the way in which we do internal investigations, and we need to think about what is the role of professionals when it comes to surveying these tools. So we do have a great panel about who will speak about that. In order to improve compliance standards, this does not only come from local legislation, but there are international legislation that keep driving new standards and demand alignment with different stakeholders with operations abroad. And like every other year, we will speak about the latest trends in Latin America and the US, and we thank the various experts that have come here today to speak about those new trends, especially given the leadership that the US have had so far in this issue. We will have today the representative of the Justice Department of the US in Argentina to speak to us. We are very thankful for her presence. We also have people from the public fiscal ministry who are working against corruption on a daily basis. They are fighting against structures of power without many times knowing the efforts that this administration is doing. We always want this to be a place not just to find out about new trends and to reflect about theoretical issues, but also to share experiences and good practices. So I wish everyone a great conference that will surely be enriching, and I hope the exchange of ideas that we have here will inspire us to work towards a more ethical and transparent country, both in the public and the private sector. I hope you enjoy the conference.
Please welcome Lorena Schiariti and Andres Farrell, partners of Marval.
Good morning. Thank you everyone for being here today. You're most welcome to our offices. Everyone is colleagues and our friends who have attended for many years, so it is a pleasure for us to welcome you and to be here sharing this fantastic conference. This year has new challenges. We have had a new administration since December who has gone for radical change to attack mainly the problem of our economic situation, but within those measures there have been a lot of decisions made that have to do with the deregulation of the economy, and that is a lot to avoid situations that may favor corruption. Beyond from that, we are all anxious to see what are the more specific measures that have been taken with regards to this issue that our new administration is thinking about. So that's why today we will hear different officers from the new administration. Welcome, everyone. Thank you once again for being here in this event that we love to organize and host. We are going to welcome now the Justice Minister, Mr. Cunio Libarona. We're so thankful for him to be here and to connect from abroad with us. It is crucial for us to have his vision on this strategic issue for sustainable growth and development in our country. Argentina is being assessed by the international community through different unilateral entities with regards to the compliance of standards when it comes to anti-corruption and with regards to its capacity to prevent and sanction those crimes. So in this relevant context, and thanking him once again for being here, we're going to listen to his words now. Good afternoon, everyone. I am far away. I am in the same line of thought that you were thinking about. It is fundamental to show the world our change as Argentina, and that's why I'm here in a symposium for financial crimes in the Cambridge University. And yesterday we spoke about the new law for confiscation of goods, and this has to do with corruption. And that's why I'm far away, but I did not want to, I wanted to accept this and thank you. This is a firm that I value so much because they are so knowledgeable. They have such a good legacy, and we've had an excellent relationship over the years. And these courses that you organize are so enriching. I have friends from school even who are part of your firm. Fernando Montes de Oca was younger than me. I used to be classmates with his brother, and I chose him to have a role in our ministry. And I've always worked with very, very nice people from you, and I don't think we ever lost a case. I remember Julio Rivera, Luciano Gen Quintana, Martin Campbell, Gabriel Matarazzo, uh, Ernest Levinson, Gabriel Golbi, and many other lawyers. And I want to highlight something that is very important. I admire the work that Gonzalo does pro bono, helping victims, and Luciano's work when he works in the Houses for Freedom and access to justice. This is something that is not well known, but everyone should know it. When I leave this ministry, I'll try to collaborate with them because the work that they carry out is incredible. Okay, let us speak about the subject. It is divided in three: compliance, the fight against corruption, and judicial investigation. I agree completely with what the speaker who spoke first today. And last Thursday, I was with the OECD representative Matia Corman, and I said that out of all the things that we were doing when it came to justice, they were they were up to date with the reforms that we are carrying out when it comes to the federal accusatory system, and he was very pleased. So I believe that it is fundamental for Argentina to change the decision that Javier Milei's government has taken with an excellent task force is to transform Argentina, for us to have a trustworthy country where laws are respected, that can have judicial security and continuity, a justice that is apolitical, fast, fair, and that helps to resolve conflicts, to do reparations, etc. And let us go to the tangible subject. Two very important collaborators that I've had, Alejandro Meli, my lifelong friend. We've been friends forever. He's in charge of the anti-corruption office, and Dr. Jacobucci, his father, was our partner in those times, who is responsible in the financial investigation unit, and that's who we are trying to show the GAFI that we will actually improve and that we will change our position. And I also want to highlight other people who have given up other lifestyles and different incomes and who are sacrificing so that we can get a better country. Let's go to compliance first. I sent you a graph to do with compliance that we set up, and also an article that I wrote a long time ago on the legal magazine that you can show later on. What is true is that the criminal code in the last few years has completely changed, and a fundamental aspect has been the responsibility of legal persons. And in the 70s and 80s, when I was studying, we did not have the responsibility of these entities. This was something that happened in the States, in England. It began working in Spain, and they were saying they that the authors, Soler, Fortan, all of the authors of legal authors, then even Zaffaroni used to say that the legal entities did not exist. And I in that article said that this would change because it was more necessary to have the responsibility for the legal persons, besides from the action of their members, it had to be analyzed. And although it was seen for some special crimes, in time I was right, first with money laundering and then with the law 27,041 from 2008. When it comes to compliance, today we have compliance. This is there, it exists, and we may say that perhaps the crimes that have been installed that are part of that are not all of them. We could have more. The responsibility of legal persons is also clear now, and if somebody makes a crime on the favor of the legal entity or person, they should respond for that. And it is clear the fact that there is a waiver if it is a personal fraud, which is surreptitious or hidden, made by the witness. The law establishes the waiver for responsibilities and for sentences in the Article 2 and also in the 9 article. There's also the measurement of these sentences, and taking the criteria that is existing in Germany and Spain, who have worked on these issues, about the position that our tribunal should take when it comes to these facts. The person in charge of compliance, as the German Supreme Court says, for control and surveillance, has the obligation of impeding crimes from the members of the company, and they may be punishable by omission. But there I face the fact that how about if they didn't know about this? Why should they be responsible? They could be an objective responsibility, but not in subjective terms. And the culpability that is guaranteed by the Constitution is not there. The big elements that are taken into account are the deficit for organization. And that's where our courts have worked on, especially the Economic Crime Court, to see if they've done what is enough, if they had some loyalty to the law and how they should have behaved in these cases. And it encourages to do the integral integrity and training programs, internal investigations, etc. And there are some aspects that are crucial: the promotion of an ethical culture, the commitment by those in charge, rules that are clear, planning, the allocation of responsibilities, surveillance, reports, analysis for risk management, and integrity programs, which is the most important thing thought about by Article 23, with ethic codes and specific procedures and periodical training sessions. Some companies do it in a responsible way. We'd like to tell you, to come out of the subject to do with compliance. I gave you an overview. The rest is in the graph that I sent you, that I think everyone knows about, to examine those cases that are always quoted. I had some of them on the Argentinian side, so I think it is important to mention them. And these are cases where this compliance law did not exist. These are from before that. This is the main example, is Siemens. Siemens in 2006 in Germany did a tendering in Argentina for our identification cards and controls in the borders. And they were in Germany, they actually had to go, they were imputed, they were indicted, and they had to pay good money in the States. And in Argentina, they had a penal case where they had two different accusations. One, that the price of the tendering was too high, and also the derivation of this money, the funneling of this money. So it is important to tell you how this happened.
So this research took place after the discovery in Germany in compliance with invoicing and where the money was sent. That's when they start to determine that there were very high amounts, $130 million paid to different people that were unknown. Therefore, they start to track where the money was going, and that's where they saw all these things coming. Not public officers, but a lot of officers, German officers from the board. There is an anecdote I would like to share with you. The judge had ordained that a Uruguayan law study was searched, and they took all the files of a special person working there. He was in charge and was part of a request for money. When I go to the court, I am speaking about 10 years ago, and I review all the documentation, I see from the file of the Uruguayan office that nobody looked at that the owner of the corporation that was paid and took the money in that accounting office was the German officer. So this person that was in charge of issuing the invoices was at the end the person receiving the funds. Even I remember very well that all his personal data was there, telephone number. We called with the notary public, and they picked up the phones. And in some cases, it was the office in Siemens, and in other cases, it was his home. So he was the person that took the money of the company. In the world, and especially in Brazil, it's very well known. There is a case in Argentina in the oral court pending litigation. Odebrecht was invoicing in Uruguay to Uruguayan officials for services that did not exist for millions of dollars. And that money was then transferred to a capital in Argentina where it was received by public officials. There were no compliance, and it was possible to detect the fraud and eventual problem of these officials that ended up with the patrimony of criminal public officials in our country. Also Cameron, United States, with another method, and Permanat in Argentina, Permanat Italia in Argentina, after emptying the company and with a fraudulent um, winding up of the company. These are some of the cases that exist in Argentina. These are not concrete compliance cases in Argentina, but compliance that took place in Germany, United States, Italy, and Brazil, and especially Odebrecht that had also offices in the United States, regularized or standardized the legal system in companies that continued working later, and Siemens changed its working culture, and the same for Odebrecht. In opposition to that, other companies ended up winding up and didn't work anymore. Our law fulfills its international commitments. We follow the commitments undertook with the Anti-Corruption Commission, with the OEDC, and this is a step in the right direction, always fighting against corruption, private corruption and public corruption. a lot of procedures, a lot of good practices, organization, implementation, execution, laws, internal regulations. It's a new culture of compliance. It's a prevention tradition against fraud, where it is promoted the ethical and social values as a way to directly protect the legal assets. So within this framework, we have Dr. Jacobucci. This is a topic that is essential within the framework of anti-corruption and the fight against crime. In particular, the anti-corruption office for me was very important to improve it. And within the scope of the Ministry of the Economy, I was speaking with Luis Caputo, the minister, and with the firm purpose that they wake up from this nap and they start to work properly. This is a huge challenge, and nowadays it is very active and they are working very well with this. We are now having a very difficult debate with Gafi and his examination, perhaps for lack of actions in the past. But within these 9 months of administration, this is now a body that was rightly conducted, always removing regulations that didn't have any sense and implemented good ones, also based in Rosario, in the frontier, and in Cusco region to have more participation. With Dr. Jacobucci, I travel a lot in the interior of the country after the implementation of the new legal system, and we always take someone from the whip so that the prosecutors are aware and the judges also about these fundamental tools and its value during research and investigations, not only for money laundering but also for collaboration about detection of accounts, corporations, financial information, cooperation with other international agencies. And apart from its administrative task, they have a fundamental role in research. And they are also a plaintiff in different litigations. I spoke about this in Cambridge, that we need to reduce and aim at the benefits of crime. The criminal cannot continue receiving the fruits of its crime. This has been said very well by the court and was accepted in the doctrine in general. But we need to be more efficient in practice. That's why we speak about an orderly decommission law, early decommission. I am convinced that if the criminal, if you remove the economic benefits, they are not going to act. So there is a lot of greed here, and if we have sanctions, we are going to de-promote or disencourage criminal activity. That's why I think in a month we are going to submit this law before the Congress. And the main purpose will be decommission. Structural problems, internet, lack of means, effective evidence means if we could use that money directly to improve the infrastructure of judges, prosecutors, defenders, then we will have a better system for sure. So this takes a lot of effort, as you can imagine. There was a law that was frozen in Congress, and the reviewers from Gafi would come. I remember in February, Saturday was very hot. I spoke with 17 senators. I had lunch in a restaurant, a barbecue with some of them, and I explained to them that it had to do with the state, that we had to be together, joined. This is for the benefit of the country, in a country that is difficult to challenge this. So there we obtained the new money laundering law that was passed the 7th, the 14th, sorry, 14th February, February 14th, and then 1 week later was approved 70-0 in the Senate and was made into an act. And it was very necessary when the people from Gafi was here and they could use it. A lot of reforms were implemented there, new amounts, new punishable acts within the framework of terrorism regulations, real estate brokers, lawyers that were criticizing me and they didn't even read the law, because the law is quite restrictive with lawyers. It's not as everybody was saying in the radio. I remember, you are going to tell about the crime that was confessed to you. Or, no, it's not like that. So this is for limited or restricted cases, international commissions. And in these cases, these are people that create corporations in different tax paradise where there is suspicious activity and where they acted willingly. They were negligent. So the anti-corruption office with transparency is analyzing lack of compatibility and claims, complaints, etc. And the second topic that I was interested to develop was corruption. Corruption is the second topic that you mentioned. I remember I spoke with Eduardo Casal, the prosecutor, about my will, 8 pages long, to create a special prosecution office against corruption. We have money laundering, we have gender, human trafficking, but well, I didn't get any answer. I spoke with the PIA office, but that project is still pending and is still in my head. We have an important law for projects for anti-corruption with some reforms. Many will be included in the criminal code because apart from what the convention says about which are the goals and the important damage produced by corruption, I think there are more. Loyalty. The loyalty of the public official is a treason by the public official, a treason to the nation, to the citizens living in that country. So it's extremely serious. So in the new criminal code, we are going to establish the different variables. That one is to organize which are the sanctions that are not appropriate, that are too low for public officials. I mean, sentences or fines had to be proportional to the behavior and also work as a reference. We cannot have an eternal litigation with a sanction that is not good enough or is in suspension, because it has to be equal to the behavior that was displayed. Also, the public official committing certain crimes had to be included in the general part for behaviors taken in the future by other public officials, so that it becomes clear. Public officials from the customs office, from the AFIP, from other organizations, it has to be for all of them, for all the crimes. Crimes committed within the framework of the exercise of their roles, of their functions. And in this same sense, something that is essential, which is the creation of new criminal titles. We have empty content. We have complementary laws that are not very much adjusted to the new reality, fraud, things that are serious, people that appoint another person that accepts a work or a position and they don't go to work. So that is fraud. They have a contract and they don't show up and they don't even have a desk. So that is very normal. That happens a lot. We have even identified people and they need to receive a sanction. Also, what happens with the social plans and the deviation of those social plans? Where do they go? They end up in cooperatives with fake invoices or intermediaries that disappeared from the social plans, or fake litigations or lawsuits. I found 3 fake litigations where they make up certain situations to collect money or repairs for the disappeared, where they submit fake documents, they trick the state. Sometimes they have all the documentation, and obviously that is a behavior that must be penalized. And during the processal stage, in our Article 172, demands the submitting fake documents. I go to the Italian system, fraud. Fraud without fake documents. That is lie to obtain prejudice against the state. Then we have private law, different from the models that we had in other countries that were more generic, they were imprecise, they were not very well written. Fifth term, we also improve another figure that was not understood, the illicit figure. We don't know if it's omission, not justifying assets, or if it's action when there is an increase of the patrimony, and the same federal chamber has different criteria that they apply. We don't know is what is taken into consideration. 1 apartment, 10 apartments. So what I wrote was enrichment at that moment without this special characteristic. This is punishable even if it's just 1 small apartment. I don't mind if it's 10 or more. Something that I am very interested also is the lack of complaint. So the people that that is a public official can do it. So to go back to the origin, and that it's mandatory to submit complaints against all the public officials, so that they are aware that they are committing a crime. Another reform is to prohibit benefits to the public officials for criminal prosecution, conciliations, suspension of payment, topics that are under discussion today. We have the decommission law, early decommission. So if we take a car or a money or a farm that it's taken, and then 5, 6 years later we can solve the decommission. So decommission must happen very quickly, and that money has to be disposed of, and if it's admitted, then the value must be returned. But to have property in a deposit, a warehouse, doesn't have any sense. The same goes for the ficha limpia or the clean file. We have established other type of actions, complaints, searches, and for us the big promoter is the public ministry. Many actions were carried out, adding financial information, anti-corruption office through the Secretary of Human Rights with repair laws, and some directly for discrimination. And they have worked very well with social plans that were fake. There are people that are being prosecuted, and people that were part of fake piquetes or manifestations. And we are now with 9 accused people where the main actor is in prison and there was an audit. There were 2,500 files. After the audit and the efforts by Dr. Banner, that was reduced to 17,000. So we reduced the number of litigation pending.
On the other hand, and this is very important, we made the administration smaller because it was inefficient when it came in structure and personnel. And there are, if we have less state, less government, there's less crimes. And we had too many employees that were not even working. We had the Ministry of Women with unbelievable plans with a lot of money and budget that were not paid to the real beneficiaries. We changed the the nature of plans. They have to be means tested now to do plans. And we've given also a battle to the register offices, which had a lot of cost for the citizens. The car, when you buy a car now, you can go down to a tax of 1% instead of 6 to 9. The same with motorcycles and vehicles and agricultural equipment. That was shrunk in half because they used to pay a lot in taxes. There were a lot of forms that were not useful at all. We also shrunk different entities. For example, CONAVI, the genetic data bank, was shrunk, and they had research. Um, um, they could actually call people. They could do judicial duties. And what we're saying is, no, no, no. You should go straight with a claim to the judges, because I clarify here. It has to be clear that the ministry, the court, I don't investigate. I don't go to courts. I give total independence, but those who need to do those tasks are judges and prosecutors. And this independence and division of tasks in these 9 months, you can see that this was an express request by President Milei, that there have been no scandal for interference, at least from the Justice Ministry, when it comes to this. And I'm now going to go towards the other subject that I was interested in, which is investigations, which is the third subject. And for me, it is crucial. We need to expand the investigations. We have many valuable collaborators here, but what I need to do is to give judges and prosecutors laws that they can work with, structures, because they don't have that, means, technology, uh, offices, so that with all due independence, they can actually do their work, their job properly. And before, we used to be completely paralyzed, and we took a lot of efforts in legislative terms, not only when it comes to the new code that I will speak about later on, but also with a new design through the penal code, criminal code, as I've said, which is, of course, much bigger, with new, when it comes to now we are going through Congress with trying to lower the age of criminality, and also a judge cases against seizures, and also when it comes to uh, firing people, we have to put a reasonable limit in all courts to be applied throughout the country, and also the jury trials to get This does not exist in federal terms, and this is something that is not from the Constitution from 1853, but it is something that from Saavedra, Juan José Pase, and the Assembly of the year 13, and the Constitution in 1819, it has never been implemented. That is something we owe ourselves to do, the trial by jury. When it comes to investigations, for me, it is crucial to implement for the adversarial system. And this is the American system and the British system. Tomorrow I'll have a meeting with British judges with this because they've come to train our judges in Argentina. It is a prosecutor who has investigative powers. They don't take it to the judge anymore versus the defense who has evidence, and the judge is completely impartial, and they only intervene when it comes to things that they need to do. And this code itself does it. Transparency, simplicity, orality, everything is digital, equal parts, and of course, speed. The timelines are much shorter. There is a special chapter on complex investigations, and this is a very important role for where victims take center stage. We did it in the province of Santa Fe, 5 judicial districts. We've made a great effort. San Nicolás, Rosario, Venado Tuerto, Rafaela, and San Rafael. And in Cuyo, enormous effort, Mendoza, San Rafael, San Luis, and Villa Mercedes, and also in San Juan. And so you get an idea, in Santa Fe, we were able to try somebody for drug trafficking in less than a month. In Rosario, in less than 2 days. And in Mendoza, we began on August 5th, and now they have 3 or 4 sentences that are firm. So we have actually changed. And this allows many agreements and many abbreviated reparations to take place, and only the big cases go to trial. In Salta and Jujuy, where this has been going on for years, only 20% in Salta and 22% in Jujuy go to trial. So it's big cases. The 80% finish with all speed, and it is simply decided. Now we go to Patagonia in November and December, and with that, in 1 year, we will have done half of the country. It's been a very big effort in a country where we have no means, and we make the most with seizures, reparations, loans, and the collaboration from the Ministry of Economy, also security. Minister Bullrich is working with me, with her team of collaborators, and our purpose and our timeline is how to finish and to solve the whole of the judicial system throughout the country. But this is not just our effort. We're working with courts, we're working with the council, with Horacio Rosati, with the different prosecutors' office, with Estela Danis Martinez, Dr. Casal. I am driving them and pushing them to be able to achieve our objectives. And actually, this is not changing a law like the books say, because it is training judges, training prosecutors, training defense lawyers, and also private defense lawyers who have no experience in this. What is hardest is that the justice system is destroyed. It's been abandoned. In San Nicolas, when we went for the first time, it was like a swimming pool because it was flooded. They have no idea what a prosecutor's office is in Rio Grande. It is terrible. The actual building is terrible. So I have to give them an office that is apt for them to work with. In the 70 years past, this has never been refurbished. Think about Wi-Fi, for example, and I have created new methods and many people don't know this, we have established labs for investigation agreements with provinces who already had it. We've brought and bought chromatographers for drug cases to be able to test the substances that have been seized. Here we had to send everything to Buenos Aires labs to do it, and with these new devices they'll be able to do it immediately. I bought also some other instruments and tools that are very expensive, but we need to have them, which are UFET. It is a phone, because this is the big evidence now. UFET opens the iPhone, and in 1 minute you can connect with all of the people that you need to investigate. I bought one for Santa Fe, one for Cuyo, and I'm trying to get the money to have one more in Patagonia. There was just one in the city of Buenos Aires, and that's where we need to have, in order to be able to investigate and in order to be able to get the system to work, to have mechanisms and new means of investigation. So may I now conclude? I don't know how long I've been speaking actually, but 2 more minutes. We must all think of a better country. I always tell judges this, and we must take care of society. That is the most important thing. That's why we are servants to society. We are not here to serve ourselves, but to serve others. And my happiness now is my achievements. When I remember the judge in Venado Tuerto, we had finished refurbishing the building, and they sent me a video of all the refurbishment, and that made me happy. When I got to Mendoza in February, the hostility of various judges, they kept asking us for more time for this. I said, this is going to be in August. They wanted me to change the timeline. And I kept saying, no, I'm not going to change it. And those people who were very hostile in February, after me going there for 4 years, for 4 times over the year, they have sent me a letter congratulating me and saying, you have been so bold and so courageous. And that's very important to me. This I have no doubt that we have a historical debt with the fight against corruption, with justice, with good courts, with a code that is modernized and a system that is right, efficacious, and fast, especially. And I hope that we will be able to reconcile justice with society, because society has really suffered, and of course credibility has been tainted. I began going through courts when I was 5 years old, so I hope that this will really change for the better. Thank you very much. Keep working. These courses are fantastic, and we will only get out of this rut with work and with education. We need to strengthen the judicial sector in our country. We need to promote culture, respect, loyalty, and the rule of law and integrity. And that will yield a better country to benefit our society. Thank you. Thank you very much, Minister. A pleasure to hear you. We had some questions, but actually he has said everything that was so important to hear. It is very challenging what we must do. And the fact that he, that we have had his presence here with the private sector is very important. Thank you so much. Thank you for speaking to us. What you've said was very interesting, and it's what we needed to hear. There is one concept that I think was interesting, which is the objective non-responsibility for the officer and the parameter to evaluate responsibility when it comes to investigations. Once again, reiterating my thankfulness to the minister. We will now continue to the next panel, moderated by Lorena, where you will be able to hear lawyers from different jurisdictions from Latin America and the US talking about the different laws in each of their countries. So Lorena will now take over. Hello, once again. We will now continue with our talks. We will have a talk about the trends in different jurisdictions. We have Fabiola and Rodriguez, a partner at Demares, Guillermo Acuña, a partner in the Kerry studio in Chile, and Christian Francos, partner from Louis Bash Kaufman and Middle Miss in the US. Did I pronounce that correctly? Okay, so I can congratulate myself. And we will now begin. And for Chile, this is a key time. On the 1st of September, the new law came into validity for penal responsibility for legal persons in Chile. What is the main effect of that law? And what type of worries did it provoke in the private sector? Thank you very much for inviting me, Lorena, and congratulations for this fantastic event. I am so proud that I am here, to be here. The law was dictated, this is the law for economic crimes, was dictated in August last year. And that law, to give you some context, was brought because there was an idea in Chile, more social and political, that crimes to do with companies did not have the right punishment with regards to the effect it had on society. There was some fraud to do with tax and others, and in the extreme, they ended up with some people who had agreements with prosecutors, and it ended up going to ethics training instead of getting punishment. So that generated the impression that there was not enough punishment. And as many times in our country, the reaction in political terms in the parliament was very drastic, and they dictated this law for economic crimes that gives terrible seriousness to these kind of crimes, company crimes. So the law, what it does in the first place, and the most relevant part of them, is that it put within this bag of economic crimes about 250 crimes that go from the traditional ones, such as money laundering and bribing, to environmental, trademark violations, sanitary violations, the violation of company secrets, etc. So pretty much any crimes that can happen within a company goes into this bag. So that's the first thing it did. And what the law did is that it made the sanctions to the people who were involved would be harsher. And then those sanctions could be harsher with regards to the company. It attributed penal responsibility to the company for these crimes that may happen within the framework of the company. And in Chile, we already had a law for the responsibility of the legal person, but this began with the 3 crimes that were the classical ones, and now we have 20 by the year 2022, and now we've gone to 270 crimes. So they have pretty severe consequences for the conference and for the companies, and this has actually generated some worries because of the risks that companies must undertake. And it has also generated activity within the companies because the law establishes that the prevention of these crimes in Chile makes the company non-responsible. So if the company has adopted some preventative measures, then they may not be responsible. And the responsibility then will lie on the individuals involved. So that's why companies are working to adapt their preventative models. They have begun with this between the law being dictated and now.
In the second part, where it says about the responsibility of the company, it entered into force September 1, so 1 year, so that the companies could adapt their prevention models. And that started now, so it's quite new. How do you anticipate that this enforcement is going to look like? We had some conversations for this summit. We were speaking about the lack of precedents, and in Chile they didn't have also too many. So what do you foresee? In Chile, there were not too many precedents. I think that what happens with this law is that there are many scopes where there is a public interest that is quite interesting involved in these, like environmental crimes and all the corruption, fraud crimes. When it's by public officials, you would expect that it's going to work, and it has worked with prosecutors investigating these cases and making progress. On the other hand, there are other crimes that are for the private sphere. There is fraud, what we call estafa in Chile, for acquisition companies. And that gives rise to this procedure. So the question there is the prosecution office that did not see an increase in their means with its law, because as we were saying before we started, this law originated from a parliamentary action, couldn't be from the state and couldn't obtain resources from the state. So for all these private sector crimes, what is going to be the attitude of the prosecution office in terms of capacity, not will, so that the research doesn't move too fast, but what happens in the private sphere? Because at the end of the day, the criminal sanction that in Chile was looked like as non-existent in the past for economic crimes, or the probability that someone would go to prison was too low. Nowadays it's higher, so the criminal action now is stronger. And what happens with regulations foreseeing some kind of protection if there exists a prevention model that is suitable? Is the one as they had in the past, or is a new one? We have different changes in the different models. In general, it's the same. The company, if they have a good model, are exempt from responsibility. So the company is protected in that sense if the prevention model is good. Then what happens with the people involved? That is the question, with executives, the officials, so that in Chile brought over a lot of worry. Many people would say, well, I cannot be a director of the company anymore. But I heard the minister a few minutes ago, in Chile, this law doesn't change the principle that exists in Argentina, which is the subjective responsibility. So none of the managers or legal representatives of Chile, because they are acting in that capacity, are exempt from responsibility. Responsibility comes from the involvement in the crime. So in that sense, if you didn't commit a crime, you are protected. But there are other crimes that can be done with negligence, like asset laundering, environmental crimes, homicide, that can happen within the framework of a company. So in that sense, we believe that a crime detection and prevention model cannot exempt from responsibility to that person, but it's going to be difficult to accuse them of negligence because that people or that company established protocols in the companies, and if there was an unfortunate situation, then that person can say, well, I was not negligent. Have you noticed any change in the structures of the companies or in the culture of the companies in terms of this new topic? Yeah, that is something that has brought over a lot of interest because when we started to work with our clients, the crime prevention responsible person would say they were worried in terms of corruption activities or commercial fraud, and they wouldn't worry about brand crimes or environmental crimes. So one of the cultural changes brought over by this was that the entire organization had to be part of the or involved in the prevention model. So that is the change because the operations manager, for instance, should be worried or concerned so that the prevention model is good, that is well implemented, people from human resources, finances, branding, for all the brands, violations, professional secrecy. So all these cultural changes brought over in different areas of the company that are part of the prevention model. And what the law establishes is that not only you should have one person responsible for this, but many people responsible per area. In Argentina, not so long ago, there was a modification or an amendment uh, for all the crimes foreseen in the code. This is a trend that you can say can be imposed in other countries of the region as well. Well, thank you very much for your presentation, and it helps us to understand this new regulation that is really extensive. It is even difficult to understand what is the scope. So thank you, Guillermo, very much. And now, Christian, you will take the floor. We have some questions for you concerning Christian works in a law firm in the United States. He works a lot with countries in Latin America and with topics related to CPA or other CPA parameters, but other topics as well, such as service business. Can you tell us, Cristiano, how does this look like? Thank you very much for your invitation. I started to work in this law firm when I was 19 years old, so for me it's with a great joy that I come back here again in another capacity. So thank you again for your invitation. It's a pleasure to be here. When we started to put together the panel, I started to think about a topic that could be applied in practical terms. So what Lorena was saying, money service business, is basically all service that is involved with the movement of money, whether it's an exchange, office, whatever. In United States, to operate this type of services, you need different licenses. Licenses that are federal and others that are state licenses. So this is an area that the Department of Justice uses to initiate a lot of proceedings. It's a very easy tool to use to monitor transactions with all the control elements of the United States through the SEC and other state organizations to detect suspicious movements that have to do with money laundering, corruption, trafficking, terrorism financing, etc. So I chose this topic because can be applied in very broad terms, not only in Argentina but other countries similar to ours. In Argentina, for instance, we see that we have a market where we have dollars, formal and formal dollars in operation in Argentina, but also um, accessing and living, exiting United States. That is one of the main businesses of the local operators. That can be money exchange offices or money dealers. We have different names for them. But this is an activity that happens a lot during many moments. So people engaged in these activities must be very careful because there are certain requirements and the activity itself based not only in changing or exchanging dollars per pesos or pesos per dollar, but to put those dollars in the United States market. To do that, many vehicles or means are used. Some means or vehicles are controlled and some others are not. So we have two perspectives. We have the person using the service and providing the service. The one that is providing the service is subject to all the local regulations and the markets where they operate in order to do that within the frameworks of the law. And the one using those services must also be careful because they can end up transferring or sending money through certain accounts or corporations where money is concentrated, there is money concentration from other corporations or other people. So it can happen that money is transferred to tainted accounts. So what happens? What is the practical result of this? When United States detect these operations, whether of a report of suspicious activity or whether it happens with cash money, they start to monitor. And many times companies or agencies, they operate in purpose with accounts that offer to this type of market to detect transfer of money of criminal activity. Once this is detected, a seizure of the company is immediately requested, and the prosecutors, in order to request this type of measurements, the level of evidence that they should submit to the judge is quite low. Is reasonable evidence, it's called. And then the prosecutors, I refer to federal prosecutors. They have specialized departments. For instance, the one that is called MLRs, money laundering forfeiture. They close these accounts, but this is not against the person. This is against the property, money. So after some time, the owner of the account realizes that they cannot move the money anymore. So that's when they raise their hands and they ask a lawyer in the United States, look, this is happening. And that's when you start to have conversations with the Department of Justice. And that is the perfect tool so the Department of Justice can make progress in their investigations. That it starts with this, and then they continue with money laundering, then conspirations to avoid regulations or sanctions, and obviously trafficking, corruption, crimes, etc. As you very well know, or perhaps you don't know, in the United States, prosecutors have a great tool to put one crime on top of the other, and that amounts to different sanctions. So a person say, okay, what is your exposure in the United States? Well, 8 years. And there, 8 years in the United States are quite true, are quite accurate. So you really need to work on prevention. When I speak with local operators, for instance, in Argentina, I am taken aback by the level of not being aware of this type of rules and the consequences crossing the borders of the United States. Because many times the operation and the profit is local. If you change pesos per dollars, you have a local profit. If you take dollars outside an account of offshore corporation in the United States or cash money, many times they don't have into consideration what happens there. And what happens there is quite serious, not only against the money, but after the money is taken, you have the criminal responsibility of the person involved. So that is another situation. So again, I wanted to tell you about this because not many people speak about this. And there is a very high risk. And this is an activity that in Argentina it happens a lot. I am Argentinian and I am very proud of my country, but in Argentina we have this activity that is quite informal. And that happens and happens for many reasons, especially because many times governments, they need to control the money exchange for different reasons. In Argentina, it's some kind of sport, and that is something to consider. And why are you so active with DOJ? Well, active during the last 2 decades after terrorism and attacks to the Twin Towers, all this money laundering, control of illicit activities, and terrorism, well, that triggered many important laws, the Patriot Act. There are many situations that have added power and elements to law enforcement agencies in the United States, and therefore all the different means through which you could use cash or you could transfer money from a country that is less trustable or have less restrictive banking systems, they can prevent this flow of money. They are looking for illicit flows, of course. So in these networks, a lot of transactions fall in. Transactions that perhaps do not have to do with one transaction that is in a pool. Indeed, so that is the main danger, not only for being involved in this activity, but also using the MSBs. As I was saying, MSB is the one moving money in different situations. A broker-dealer can also move money or transfer money. I will I will speak briefly about an example about the foreign dealers. So this has given the DOJ a lot of tools. Prosecutors and public officials in the Department of Justice will tell them in a very formal way and not with not so many details as I am doing it. They have an enormous amount of power. And that's how research or investigation starts. And then they continue because the people that have their assets frozen in New York, then they go ask and they say, okay, perhaps I can give you some of the money back or all the money back, but you have to give me all this information about your customers, about what the level of expenses, explain all the origin, intermediate, and end user of your money, what your clients do, and if you comply with the standards that the Department of Justice estimates that are sufficient, which are quite high, perhaps you recover some of the money, but perhaps you don't. And perhaps that person gives information about another operator that is involved. And that's how there is a machinery that is amazing and is the machinery used by the government of United States to enforce these topics. So they start with something small and then they discover gold. And that's how it happens. And what happens in Argentina? What is the consequence of that in Argentina, in Latin America? Well, what I was saying before, this applies especially in jurisdictions where there is a lot of informality and entry and exit of dollars to United States. Of course, United States loves that we send our dollars over there. They have the monopoly of the printing of dollar and the administration of dollar because 99% of transactions in dollars they are part of a concentrated market in the United States, many times New York. So the power of investigation they have, the machinery is huge because they have the jurisdiction. So for local operators that are going to provide a service to a customer, this customer brings cash money and they say, I will need to put this $100,000 in my account in the United States, but I don't want to go to the Central Bank of Argentina because I'm going to lose part of that money. So I'm going to give it to you and you put it over there. And the operator charges a fee for that. When that money enters United States, from the moment it enters the movement in the market, if you don't have the license as a MSB at federal level that is submitted before the WIF or the state license, we can speak about New York or Florida, which are the typical markets for Latin Americans that also have very high level requirements. if you do not have those licenses, then there is a crime, and it's a serious crime. But again, it accumulates with other series of crimes that are more serious. So again, it's not about money, but about criminal responsibility of the parties involved in that chain. And that chain is quite long. It's not only what we call the cueva in Buenos Aires, the place where you exchange money. All the persons involved in that chain. Let's speak about cryptocurrency, for instance. If you operated in the selling or buying of crypto and a portion of that operation moved through the United States, if it was done commercially, if you are obtaining a fee for that service, then it's also an MSB because you are intervening in the movement of that currency. And interpretation of the prosecutors is quite broad because they have the power. They dictate the rules, and then you need to go and explain and convince them that they give you your money back. So for all these markets that have great levels of informality, this is something to consider because prosecutors are looking at every movement and they have very powerful tools to achieve their goals.
Can you give us an example so that we can actually understand it better? This is something that I'm passionate about. It's a case that involved several local firms, among them Andres, guiding our customers, our clients. I think it was 8 accounts in a bank on Manhattan. They had money that came from the operation of various MSVs from Argentina, different illegal exchange houses. They were all in Argentina. They had been opened through the service of a person who was like a broker that opened these accounts in the States. Those 8 accounts, ones were paralyzed with a seizure order, which was given by a judge, requested by a prosecutor. The clients started getting lawyers, and we started asking as lawyers. For 2 years, we represented these clients, and we had to give very detailed and lengthy information with a lot of questions about transactions that they had facilitated. This had to do with information about the clients, what was their work, and I had to explain to the prosecutors, for example, through a legal opinion from one of our legal entities here, why the contado con liquidación is a legal instrument that Argentina uses to bring dollars into the country. And the American prosecutors are very, they don't use a lot of ambiguity. In Argentina, we have a gray scale that is endless. And I was trying to explain, I understand that this sounds bad to you, but this is legal in Argentina. So please don't look at the transaction in Argentina because that has its own legislation. Let's look at it until when it comes into the States.
And after a lot of time, they returned 100% of the funds. And for the Department of Justice, that is quite strange. There was a series of accounts that were not able to explain this. And I have over here, if you are interested, you can have a look later. This is an annex incorporated to a demand. And after the seizure or the attachment, the prosecutors have 90 days to do two things: whether to provide an argument of why that money should be confiscated, criminality, evidence, etc., or to return the money, to lift the attachment.
And in our case, we did not get to the seizure because we got the money back. But in another case, which is this, we had 2 or 3 of these, we had the seizure demand, and it's very interesting. You may read it because the prosecutors explain here general explanation of how the blue market works in Argentina, the blue dollar market. It is amazing, but they actually explained step by step this with graphs, how the money comes out and how it comes in, the intermediaries, etc. I thought that was impressive. I could not believe that the focus was on something so basic. Argentines know that it's illegal, but it is something that is acceptable. And in this case, what had happened was not just the MSV issue, but also to open the banking account, they had used false information. It's very hard for foreigners to open accounts in the US. So if you give them, for example, the invoice in Miami from somebody else, you change the name and you put your name on it, or you explain to the bank, for example, what the use of the account will be for. And this company had said, I'm going to have a common investment fund. I'm going to do redemptions, investments, and that was a lie. The goal was simply to get dollars out and to bring them back in. And that's all explained here. They opened such a society, they took a common fund, and what was behind it all was the blue dollar operation in Argentina. So in this case, this came out good for us because we were lucky because out of the 8 clients we had, the ones who hired me were very serious. They had all the paperwork. They had all of they were broker dealers regulated in their own jurisdiction. So they served certain requirements and they were very organized and dutiful. So did others did not have the background documentation and the money was seized. And after this, what we don't know is that you can have penal responsibilities, criminal responsibilities, and the investigation is wide open because there's money laundering involved, there is having false documents, banking fraud. This is potential for prison, actually. So the prosecutors, people have to go and declare everything. That's how they get the evidence to be able to carry on with the cases. Thank you so much, Christian. This is an issue that we do not pay enough attention to in Argentina because there are many marginal behaviors in Argentina that are normalized and standards. So it's very important to look at this more. And now we go to Fabiola, who will tell us about a subject that we will return to, which has to do with the regulation in Brazil of everything that is cryptocurrency. What can you tell us, Fabiola? Thank you for uh, inviting me. I speak Portuñol. I am here thinking that I am going to create words and you may understand and my friends will help. Thank you. Why speak about money laundering? And it's great to speak after Chile, who has a new law that is very harsh and there is control. Brazil, we have the law, the responsibility of the legal person. Now a bit more due to cryptocurrency, but not because there is a law for liability. But when we think about legislation, for us, regulation is almost 2 years old. When we began regulating was after the Lava Jato, which is not a good example when we look at it from today's perspective. But for us, money laundering is very important due to the prosecutor's office. Why? Because it doesn't, no matter what you do before, if it is a small infraction, or if it's a small crime to do with corruption, but it may be involved with money laundering. It may be, Brazil is very big, but there are legislations that are statewide and others are nationwide. So money laundering is important because no matter what you do, you may be involved. And then in Brazil, you may begin an investigation by the chief of police may begin it. The prosecutor's office can also do it, and also international cooperation. So it could begin any which way. And we have the central bank. For us, it's important because it has a lot of regulations. So we think about that, COAFI, where there is a sort of monitoring of all the suspicious activities. There are many people who have to inform when there is a suspicious activity, central bank, and bingo, we also have crypto. What happens in Brazil is we're going to look at an informal transaction that is very easy to do, and that is the problem. I have here the worst or the best weapon. I can do everything I want with my cell phone. Almost all the crypto operations are done via an app. So this is my treasure because everything that people in Brazil want is the cell phone. And what people want is the WhatsApp. So what happens in Brazil is that we have a regulation that is more important now, fraud, due to cryptocurrency, because it is very difficult to get evidence. Oh, it's too easy to get it. So we do have a penalty that is more severe. Then we also have the tax fraud, because of course, not like in the States, Christian has said it's too complicated, but for Russia, we have a lot of investigations from Hezbollah because terrorism, because of the war. So it's very easy to cheat the system for people who are considered forbidden. So we have fraud, money, tax evasion, money laundering has a more serious penalty, punishment. On the other hand, the thing is, who can begin to do an exchange? They must have money. They have to have expertise as well. So it's very easy to open an exchange in Brazil to do the intermediary of crypto. What you formally need is not cash, because cash is something that in all prosecutors' office would be considered suspicious, but you do need a bank account. Christian, I'm going to ask you something. Because for Brazilians, you look at the US, because the US works. If it works in the US, it doesn't work here. What happens is that in Brazil, there is no education of the authorities. So we do have the law, we do have the penalties that are a bit harsher, but everyone is looking, the federal police are looking at crypto fraud. 1 in 5 Brazilians, and I believe it's 2 in 5, do movements to do with selling and buying crypto. It's about 300, 400, 500 reals. So it's very easy to buy and sell because it is globalized. So I can choose where to buy it, who can see it. It has the perception of pseudo anonymity that is important, and there is the perception of pseudo compliance. And that is a point that I would like to highlight after hearing Cristian and Guillermo and Andres, if he wants to speak to me, which is what happens in Brazil is that we do not have the authorities educated. So authorities, for example, if I look at an exchange, there is a control of client. Who is the person who is buying and who are they going to sell the crypto to? So you have the ID on one side and on the other side. But for police, that's not enough. Where does the money from the first part come from? And where does it go after you deliver the crypto on the other side? So what they're asking is the customer. So you have to do the compliance of the person who's buying. Yes, of course, but we have the bank. But the bank, it does the compliance. There is an account. It can be Itaú Bank, which is a very important bank in Brazil. So that's not satisfactory because right now authorities are not asking the bank, but those people who are doing the exchange. That is it is possible to freeze all of the money. So the bank transactions that have very big volume, we're not speaking about thousands, but we're speaking about millions. So high transactions, it's very easy to freeze the assets and the money. The first question is, do you want to confess and negotiate? What will we confess? We're going to give the identification from both sides. It's not enough. So now what the police are doing is investigating in depth to be able to get all of the parts that are involved. Imagine if it's too easy to do with an app to buy and sell crypto, the amount of information that it demands to be able to get the information is small. The amount of information that you will have is not much. So imagine with cryptocurrency, we do have a regulation today which will continue through the regulated financial institutions. But this began 15 or 10 years ago. And we have investigations now that are questioning our clients from 2017 or 2018. That's when the operation took place. And the documentation, when they ask for it, we don't have it before the regulation. So what is happening in Brazil is the presumption. We don't need to prove guilt, but if you don't have enough documentation, you're guilty. It's easier to freeze assets, and it's also very easy today to go into the office or your home and to get the cell phone. For Brazil, if you work at home, that is suspicious. At home and with just a cell phone, that is indication that you shouldn't even try to defend yourself. So I'm interested to hear Christian, because Brazilian justice, when you speak to the police chief, for example, when they say, can you give us the features of this person, they don't know. You speak to the judge, they say, or speak to the prosecutor. We don't have both points of the chain. If I am an exchange and if everyone else is doing transactions with me, it may be that one person will have the information, but I cannot, and I don't have enough visibility. And what they will ask of my client is, don't do the operation. It's the same as saying death of the legal person. So right now there's many operations. There are operations of the Brazilian forces, especially because we are very careful with the financial part. We not so much with the terrorism side. That has risen a lot. So now what's happening due to the war in Russia, in Israel, Iran, etc., is that there is a lot of money moving in cryptocurrency that is being sent to support the war. That is a subject that we're very interested in. How is Brazil regulating money laundering and sporting bets? Uh, what's happening is that we have a culture of betting. That is the truth. There is legislation now that they have very small punishment. Sometimes they're harsher. Bingo, for example. Bingo, for example. They open these bingos everywhere. The sport is everywhere in Brazil. So what is happening right now is that we have legislation from 2022 with a fixed amount. So we have influencers, and influencers began to advertise all of these things. These are games that they can bet on, sports events that they can bet on. And how should we look at what they're doing and be able to repress that? When it comes to games and betting, what we need is to continue with the regulation, because 15 days ago, and part of the regulation means that you have to, in order to have a betting office, you have to be Brazilian. 20% of the capital must come from Brazil, and on the fiscal part, you have to give 30 million to the government for the permit. Imagine in 1 week, 34 billion came into the economy. So it's a good equation. So what's going to happen is that right now, there's no way to control the people who are betting. And what happens is that there is an issue of these people, and there's also fraud. And how to do the investigation to know if their fraud is because you don't want to pay to the betting house, or because the betting house has a financial debt. So something that is important to us is to see that with the amount of people who will begin with this, in 7 days they must decide and say, there's a very, very bad problem to do with work. People who will be sick, who will be betting within the work environment, because of course they have an app to bet.
So when we speak about games, we are speaking about an important moment in this regulation. We have received many foreigners that would like to invest, but we don't have security that how the police is going to apply or enforce this. We are going to work in Brazil. We need security and, of course, work. Something important to mention or to notice that it depends on interpretation by the police. So the police force are agents of what the prosecutors decide, and they are not. There is not much independence of criteria. So that is something to notice. Yeah, it's complicated. And especially because, like in São Paulo, we have a specialized police that understands the debate. However, 5% of the police is involved with this. It's like when we started about the virtual crimes discussion. We didn't know how to present it, and now they are all busy with investigations in this topic. But what happens is with experts, expert matters, how you can prove, how you can obtain evidence. It doesn't matter what side you are on, the betting house, the other party, the company, it doesn't matter. How do you obtain evidence and respect the privacy law, etc.? So I don't have an answer for you. We are now in the middle of this because we are very enthusiastic about receiving investments. But yeah, that is something in Argentina. That is the trend also in Argentina in terms of regulations and how do you apply the enforcement later on. So thank you very much. Um, you helped us to think with a new approach, to understand other things, and we would like to invite you to a break. Let's meet again in 15 minutes. And later on, we are going to speak with Gustavo Giai. He's going to be the moderator of the next panel about artificial intelligence and compliance. He's a partner of our IT department. So let's meet again in 15 minutes.
Muy bien, muy contento con el evento.
Bueno, ¿cómo viste los primeros paneles hasta ahora en esta 7ª edición?
Bueno, la verdad que primero que nada la convocatoria que supera año a año todas las expectativas y cada vez vamos marcando, digamos, un número más alto, así que la convocatoria y el interés excelente. Los paneles muy interesantes, todos temas actuales, se nota la cantidad de seguidores tanto en el espacio que tenemos acá en Marval como a través del streaming, las preguntas, el nivel de los expositores nuevamente es súper destacable y bueno, la temática muy actual, así que son paneles que tocan temas que interesan a la gente. Esto no es teoría, digamos, es la problemática del día a día de las empresas.
Bien, ¿y tenés alguna expectativa para los paneles que vienen ahora a la tarde, algo que estés esperando escuchar?
Sí, mucha, mucha. De nuevo, excelentes expositores, creo que todos aportan desde su lugar, combinando distintas funciones, como es del lado nuestro, que es el asesoramiento legal, dentro de las empresas y las organizaciones, los funcionarios que tienen la mirada también desde el lugar público. Creo que se van a armar diálogos y debates muy interesantes, así que tengo una expectativa súper alta.
Bien, ¿cuál crees que es la importancia de este tipo de eventos que se organizan?
Creo que la importancia es sobre todo poner en un mismo lugar a los distintos actores del compliance. Compliance es algo relativamente nuevo, quizás se arrancó algo disperso, encontrando su lugar entre legales, entre cuestiones que hacen por ahí a las buenas prácticas, pero en algún momento se le encontró un nombre y se empezaron a aglutinar a esos actores y a ordenar la práctica. Entonces, creo que esa es un poco la clave de generar este espacio y bueno, la respuesta de la gente, la respuesta del mercado, la respuesta de los clientes y el interés además de todos los actores en participar y aportar su granito es la mejor muestra de que hacía falta un lugar así.
Bueno, muchísimas gracias, Rodrigo. Estamos acá con Paola Forchacín, asociada de Marval. ¿Cómo estás?
Hola, ¿cómo estás? Buen día. La verdad, muy contenta de haber podido participar un año más. Los invitados, los oradores, todos muy interesantes, todos con algo nuevo para compartir, así que excelente la experiencia y la oportunidad de estar acá.
Muy bien, ¿cómo viste estos primeros paneles de la mañana?
Muy interesantes. Estuvo el ministro de Justicia, que bueno, estaba desde el exterior, pero nos compartió un poco la agenda de lo que se viene, las reformas que se buscan y cómo la nueva administración está trabajando para fortalecer todo lo que tiene que ver con el marco jurídico, ¿no? En torno a lo que es la integridad y la anticorrupción y demás, así que súper interesante. Y ahora con oradores de distintos países del mundo, todos compartiendo un poco y comparando sus regímenes jurídicos, así que la verdad es que muy enriquecedor.
Muy bien, ¿y cuáles son tus expectativas para la tarde? ¿Hay algún tema en particular que estés esperando escuchar? ¿Algún speaker?
Bueno, ahora tenemos el panel de inteligencia artificial, eso me parece que es un súper tema, así que con mucho entusiasmo vamos a ver qué nos cuentan y qué más vamos a aprender.
Bueno, muchísimas gracias. Bueno, estamos acá con Andrés Farrell, socio de Marval y coorganizador del Summit. ¿Cómo estás?
Muy bien, coorganizador junto con Lorena, Muy contento, muy agradecido, la verdad que la participación es espectacular, tanto de los asistentes como de los speakers, salen temas súper interesantes, súper novedosos y que nos hacen pensar que es un poco la idea de este evento.
Muy bien, ¿cómo resaltarías o hay algo que quieras remarcar de esta edición con respecto a ediciones anteriores? ¿Cómo están viendo el evento?
Bueno, el evento muy concurrido, con mucho interés como siempre, los temas, los temas generales son históricos, pero digamos tienen aspectos novedosos y lo que destaco tal vez de esta 7ª edición es que tenemos un panel o un tema que es genuinamente nuevo, que es el de inteligencia artificial y es el que empieza ahora en unos minutitos.
Bien, buenísimo. ¿Nos puedes contar un poco de cuáles crees que son los principales desafíos o posibilidades en cuanto a la inteligencia artificial en el mundo del compliance?
No le quiero robar el espacio a los panelistas, pero yo creo que vinculado un poquito con lo que surgía del panel anterior en temas de investigaciones que requieren procesamiento de mucho volumen de datos, creo que la inteligencia artificial ahí tiene un potencial enorme, por lo menos en el corto plazo, y en lo que es mediano y largo plazo ya se lo dejo a los expertos, pero no me animo a decir porque creo que ya estaría mintiendo.
Perfecto, bueno, muchísimas gracias. Bueno, estamos acá con Santiago Carregal, chairman de Marval. ¿Cómo estás, Santiago?
Muy bien, la verdad que encantadísimo por esta convocatoria que hemos tenido, los paneles muy buenos hasta ahora, mucha convocatoria, muy interesante el tema, con muchas ganas todos de generar un ambiente de intercambio de opiniones y de reflexión para mejorar la percepción, digamos, del índice, digamos, de corrupción que tiene la Argentina en el mundo y de mejoramiento lo que tiene que tener en este aspecto para poder volver a insertarnos en el mundo. Así que muy divertido, muy interesante, muy bueno.
¿Hay algo que te gustaría resaltar de los paneles que estuvimos escuchando hasta ahora? ¿Algún highlight?
Bueno, la verdad es que me interesó mucho lo que está ocurriendo en Chile con esta nueva legislación. Muy interesante toda la parte de cripto que hablaron también la experta de Marest, que ocurre en Brasil. Muy interesante lo de Cristian Francos respecto del enforcement que tiene Estados Unidos. Y muy interesante también lo de nuestro ministro de Justicia, Cuño Liberona, respecto de los diferentes esfuerzos, diferentes ámbitos que están haciendo en esta materia. Así que muy bueno.
Bien, ¿y tus expectativas para los paneles que quedan en la tarde, que todavía hay bastantes?
La verdad que el de ahora de inteligencia artificial va a ser un panel súper interesante, es una cosa absolutamente transformadora en el mundo, que realmente va a generar muchísimos avances en todo lo que es investigaciones, en todo lo que es el procesamiento de datos, y también va a generar mucho desafío a los profesionales respecto de cómo monitorear esa herramienta, ¿no es cierto? Así que eso va a ser muy interesante.
Bueno, muchísimas gracias, Santiago. Bueno, estamos acá con uno de nuestros speakers. ¿Cómo estás? Bueno, ¿cómo ves el evento hasta ahora? ¿Cuáles son tus impresiones?
La verdad que es un evento que me encanta, lo sigo hace mucho tiempo. Me parece que Marval, de manera muy inteligente y práctica, pone una agenda que te presenta los temas de punta del momento, los temas prácticos, las distintas novedades legales. Y es la verdad que un evento fantástico para que todos los profesionales de la industria, compliance, anticorrupción, investigaciones, que les pega toda esta normativa y estos temas de enforcement, se vengan a informar. Creo que Marval le hace un gran bien a la comunidad de compliance, a la comunidad legal en todo esto, ¿no?
¿Algún highlight o alguna cuestión que quieras resaltar con respecto a lo tratado en tu panel?
Bueno, nosotros ahí tratamos distintas tendencias de cuestiones que impactan en América Latina. En mi caso particular, siendo un abogado argentino y americano, lo que traté de hacer es traer un tema que es de ley americana y de enforcement americano, pero que tiene un impacto enorme en Latinoamérica, pero especialmente en Argentina, un tema muy actual. Y mis colegas en el panel dieron unas visiones realmente muy interesantes sobre lo que pasa en Chile y en Brasil, que son dos mercados que para Argentina son fundamentales, ¿no?
Bueno, ¿y alguna expectativa con respecto a los paneles que vienen? ¿Algo que te gustaría escuchar en particular?
Mira, como argentino y como abogado, yo me encuentro muy esperanzado con el gobierno y con el cambio que se ha dado en Argentina a partir de diciembre. Me interesó mucho escucharlo al ministro de Justicia cuando habló de estas cuestiones. Y también creo que va a ser muy interesante escuchar a los distintos funcionarios del área, de las áreas que vienen más tarde, como ser el presidente de la Unidad de Información Financiera, como ser el titular de la Oficina Anticorrupción. Todos sabemos que estas cuestiones hay que hacerlas bien. Entonces, cuando uno escucha que de parte del Estado, digamos, vienen profesionales que realmente manejan el tema y que son profesionales que, como dijo el ministro, podrían estar ganando mucho mejor en ámbitos privados, ponen su esfuerzo y ponen su esfuerzo, su conocimiento en el beneficio de la patria, ¿no? Y eso es realmente muy interesante y muy esperanzador para mí como argentino.
Bueno, muchísimas gracias y muchísimas gracias por tu participación hoy.
Gracias a ustedes y por la invitación y por por este evento. Gracias.
Bueno, gracias. Bueno, estamos acá con Lorena Scheriti, nuestra otra coorganizadora del evento, socia de Marval. ¿Cómo estás, Lorena?
Muy bien, muy contenta. Ya pasamos la primera parte, la conexión vía streaming del ministro, que era todo un desafío técnico. Y la verdad que muy bien, récord de audiencia presencial. Nunca vi tanta gente, la verdad que estamos re contentos, muy contentos. y el primer panel que tuvimos, la verdad que fue bárbaro. Había mucho conocimiento entre los participantes del panel, así que y los temas fueron todos muy novedosos, así que todo fluyó muy naturalmente, así que estamos muy contentos.
Buenísimo. Bueno, esta ya es nuestra 7ª edición del Summit. ¿Qué diferencias podés ver con respecto a ediciones anteriores? ¿Qué tiene de distinto tal vez con respecto a temas?
Bueno, un tema que se impone ahora es el tema de la inteligencia artificial, que va a estar presente en los distintos paneles, porque digamos, en las distintas áreas y disciplinas que vamos a entrevistar, vamos a estar volcando preguntas sobre inteligencia artificial. Y otro tema, obviamente, distintivo de esta edición es que tenemos nuevas autoridades en la Administración Nacional. Tenemos la presencia de la representante del Departamento de Justicia de Estados Unidos en Argentina, que nos va a hablar de FEPA, que es una nueva legislación americana, también de aplicación extraterritorial, que ya no pone el foco en las empresas. Digamos, la FCPA sigue existiendo, pero ya el foco no está en las empresas que pagan los sobornos, sino en los funcionarios públicos que los piden o los reciben. Así que, bueno, de eso nos va a hablar hoy la representante del DOJ en Argentina, así que nos parece que eso es de primera mano la más importante a nivel Estados Unidos y legislación extraterritorial.
Bueno, muchísimas gracias, Lorena.
Good morning. Welcome to the Artificial Intelligence and Compliance panel. I am Gustavo Giai. I am a specialized partner in intellectual property and technology of this law firm, and I have a great pleasure to introduce two colleagues and friends with whom we are going to speak about this topic. First, Kanel Kahneman. She is an AI expert in global, specialized in this topic. Karen is a lawyer, and David Mielik, apart from being a lawyer, he is head of artificial intelligence from the prosecutor office of Argentina and legal department. With Karen and David, we are going to try to analyze what is going on within the framework of this technological transformation that is taking place, that is huge, as you very well know. We are experiencing it as professionals and as an industry. And we are going to speak about the topics that are most relevant for compliance. I'm not going to give you a very big introduction about this topic because the people present and people hearing remotely know that there is a huge transformation that brings about a lot of opportunities to incorporate technology in a positive way. There are risks involved as well with this incorporation of new tools and technologies, and there is a market that is trying to look for a maturity level and its own place so that this can be solidified. So we are going to try to speak about compliance in relation to this, and this is an area where this transformation is under development. As we will see later on, there are some topics that must be discussed, and we have more questions than answers. Trying to shed some light in this, I would like to ask you, Karen, as a starting point and to contextualize this topic, where are we standing? Can you tell us how the technology in the legal industry has evolved until getting to this very moment where artificial intelligence has disrupted very much and moved the basis of what we have seen so far? Can you tell us a little bit how technology was able to transform the current situation, and we can have a deeper analysis of the technology related to compliance? Thank you very much for your invitation. I think this topic summons us all because we know that is the practice of the future, and also to understand how it has been evolving, and that will show us that something very important, that we have been part of this procedure, of this process, and if we can have historical background of how this started, automation of legal processes, automation of paperwork, we can say that up to the 90s, just to give you some reference, the major part of the programs that we would use inside the law firm or in-house office would be programs based on rules. A program based on rules is a program that applies the yes and then rule. So yes, I do have an NDA, so I can attach it to an email and automatize this workflow. So yes, and then I find that solution. So what happened with these type of systems? Well, they were not flexible enough and could not be adapted to certain circumstances or certain demands of a lawyer. So technology itself started to evolve until we get to the stage of machine learning processes. Machine learning is another technology. I'm not going to go deep into details, but you know that we use it a lot, especially in compliance, everything that is related to detection of potential frauds with credit cards. They use the structure of machine learning with non-structured data or with non-supervised data, and at a certain moment they will continue to use it, and we will say something about this later on. But machine learning at a certain moment was the first step towards what ended up being the deep learning. Deep learning, different from the yes then, would help you or allows you to have a review of the documents, so to understand the content of those documents with different programs that are more developed in terms of natural language processing, as they call it, which was a deep learning tool that enabled these type of developments for everything that is related to the review of contracts, agreements, clauses, detection of certain rules. And with the arrival of the large language models, where artificial intelligence is supported, the difference is that apart from reviewing content, technology can create new content. And that's where, with a little bit of training, we were able to see the acceleration of this technology during the last few years. You can imagine ChatGPT was launched at the beginning of 2023, and then in 2024 was already the Barcamp in the United States with version 4.0. So that tells us that there is a huge acceleration of the technological development of these tools, and that brings about the opportunity to start to understand a little bit more what is generative artificial intelligence to accompany the development that is coming. Where do you see the pain points of this generative artificial intelligence with the incorporation of software or tools that include it in practice, in your daily practice? Or let me tell you, both of them have gone from law to technology, and they come and go all the time, so they have a comparative advantage compared to the rest of the arts mortals. So in terms of what they see, what do you see today is a pain point that the generative artificial intelligence can alleviate, if, for instance, in prevention methodology? The pain point is in itself a problem that we have in our daily legal operations, and we can solve it with the use of technology. When I can speak about pain points in compliance, I can imagine many of them, because I can think of, and not only with AI, we can solve it with technology. I can imagine a screening of compliance where all of a sudden the supplier of the screening uses a technology and we use another technology, and the department of purchases or the customer or the business area uses another one. So with all different data that cannot cannot be crossed over, and it takes time and resources of valuable persons, people that would be um, putting their time in other activities that bring over more value. So those pain points that take time and resources and money can be easily solved with the implementation of, first of all, workflows that are the workflows that the procedure that we want and we think it's the most efficient, that connects the different systems with APIs, which are the connectors between different softwares that we were mentioning before, and lastly, artificial intelligence to extract data of the entire screening process to generate conclusions and decisions based on data. So that is one of the pain points, screening of compliance. The other one I can come up with, and that I think it's interesting, is the detection of risk. In the compliance area of healthcare, they are using monitoring of words that can imply certain red flags for behaviors. There is a very well-known case that won a prize in Stanford, which is an artificial intelligence assistant that reads the contracts or agreements that the client can send, and based on training that we have given with compliance rules, can detect whether the contract has the CPA clause, if it includes the UK Rivalry Act or not, if there is any other risk that we would like to detect. So the good thing about artificial intelligence is that we can feed it with the criteria that we want, so that it can search for that information and create content or a summary, such as a different chart with risks or these types of breaches between doing this task manually or involving resources that can be assigned to other more important areas. And in terms of assistants, you were saying there is a virtual assistant. How do you see that in the practices? How do you see that working? And how difficult or challenging is to obtain those type of virtual assistants to work in compliance internally? Well, I think I had this conversation with you the other day. It happened, you are a lawyer and the rest of the areas or the clients themselves, they don't read what we read or what we send. They don't get to the details of page 15 of what we wrote, or the policy or the code of conduct or the guideline or the framework. So a RAG assistant is an assistant based on generative artificial intelligence to whom or to which you can feed the code of conduct, the guidelines, all type of documentation that is related to the area, and that assistant will be able to answer queries, such as if you are speaking with the document yourself. So in terms of business value and technical complexity, this brings a very high value of business and low complexity. They are very easy to design and they can answer queries for members of an organization and even for customers in a very efficient way. Some people that have questions about the code of conduct of the company, they are going to hire in an easier, very easy way. And also taking less time to send emails to questions of the people from compliance department and answering those emails. So it's easier. In terms of development, what we should consider when we think about something like this, an assistant, as Karen was saying. Well, for me, it's a pleasure to be here with you guys, first of all. As Karen was saying, we are now in a moment where technology is so mature that brings an opportunity for the legal teams, for the larger law firms and the smaller law firms and the smaller in-house teams to have your own developments for artificial intelligence. We are now in an historical moment where technology is mature enough so that can be appropriated by the different legal teams of any size and with any budget. Just to give you an example, I was developing applications with artificial intelligence. One of those applications that I developed was used by the president of the fiscal court of Argentina, and someone asked me, can we have our own development with artificial intelligence with access to the jurisprudence of the court that is difficult to have access with? And the vocals and the teams, they rely on their memory about this and this case. So now we have a context where we don't have enough budget and we need to apply very new technology. Yes, we can do it. So these type of things are being requested all the time. The models that Karen said, the generative artificial intelligence models are general models that can answer certain legal questions and also teach us about piano and a recipe about spaghetti with bolognese. And sometimes you just need a model or a AI that is specialized in legal matters, and not only legal matters and compliance, but specialized in your database of your own legal team and the services you provide in-house or externally or as part of a law firm. So I think this is a very nice opportunity. You don't need to go to built-in software or solution. You can have different budgets for customized solutions that will be more secure in terms of data and very much well prepared to deal with the flexibility demanded by each of the teams and with the criteria applied by each of the teams. So this opportunity that didn't exist in the past because programming based on rules was rigid and there was always a lack of connection between what the legal teams could offer and what the legal teams needed. But to give an answer to these opportunities, we need to face many challenges by the legal teams and the people that are part of those teams. The first one, I would say, is to know what to do with this technology, because there is a temptation of saying, okay, let's put artificial intelligence to everything and let's solve all of our issues with artificial intelligence. And even now with generative artificial intelligence, which is like the password that is the answer to all of our problems. And then the challenge is, first of all, to understand what you need for your team, and not just to put the carriage in front of the horse. So to have a clear understanding. And that is not a trivial decision. That is a decision that you create after training, after your experience, and after the legal teams have had the training and know which are the available technologies. That didn't start with ChatGPT or the ones that we were aware of during the last few years. They have been there for a long time, and they entail different levels of complexity. There is some solutions can be or some problems can be solved with deep learning, some other problems can be solved with artificial intelligence or generative artificial intelligence. So it must be adapted to all the teams, and it can happen having a sophisticated level of understanding that nowadays I think it would be a debt in terms of legal teams about how this technology works, what can be done with it, and what are the limitations. So first of all, you need to know what you can do with it. The second challenge is how to do it. Because again, the lack of knowledge in terms of what you were saying, this bridge between artificial intelligence and law, is a bridge that we need to walk over. I mean, after many years now, I have been teaching artificial intelligence applied to law in universities in the different courses. So for the next lawyers, after graduation, they have a baggage of information, of knowledge, and they can apply these to their daily tasks. So that is something that we can have access to with different training and courses. So this is in our reach. But how to implement it? Just to give you a compliance example, detection of online fraud Of course, artificial intelligence is trained with all the data that you can find that shows trustworthy reality. So you would like to train this artificial intelligence memory with data about fraud. We want artificial intelligence that can help us to obtain red flags, early alerts that this operation or this other can imply certain level of risk or non-conformity or non-compliance. So you feed an AI with that base of knowledge, with that experience that the legal team has about all past activities and all past situations where there were non-conformities. But what happens is that 98%, 99% of those activities were licit, were legit. So that can provide or give a bias to the algorithm in order to maximize the efficiency to which it responds, just to say that the correct answer is the transaction is legal. So 99% of the cases are correct, but 1% of the cases are the ones that you are interested in, and this technology is not going to be sensitive enough to detect those cases. So, in a certain way, this algorithm is 99% efficient, but having more knowledge or going deeper into the topic, then it's not enough. It's not enough. It's not good enough. So, how you can assess artificial intelligence systems? That is something that the legal teamworks need to adopt by themselves. They cannot just purchase a tool that says 99% efficiency. No. What is the 99% efficiency? In generative artificial intelligence, the problem they have is incorrect answers, what we call hallucinations, even in systems that are trained and feed with their own information. The risk of an incorrect answer in compliance in the legal sphere, it's quite delicate. An incorrect answer can happen from two different areas, like lack of information or things that says or a false positive, a content that it says is there and it's not. All that can be assessed because the benefit of this is that you can understand what is the level of accuracy and to understand whether I can use it for what and with which percentage of accuracy. So to know what we can do with artificial intelligence, how we can implement it well, and then to have a clear awareness of protection of data, understanding that these are complex data that are mobile. Part of the processing can happen in Europe, in United States, and another part in Asia. And you need to comply with all the regulations and with all the data protection rules of those countries. So data governance and artificial intelligence together with the legal teams, they have to become a very good and strong team working together to obtain the best results.
So when it comes to investigations, where do you generate most impact of the usage of generative AI in investigations compared to the scenario before these existed? I believe it will be a complete change of paradigm if you understand how to use it properly, of course. The possibility that Gen AI gives, is to delve in non-structured data in a faster way, exponentially faster way than you were doing right now, up to now. Gen AI will make lawyers at some point, not now, but at some point when the fine-tuning is done, it will be for the lawyer what the calculator was for the accountant. It won't solve the problem itself, but it will allow you not to keep counting with your fingers or not doing things so manually and so time consuming that in the end you end up becoming obsolete when other players who will use AI. So I think the chance to actually generate knowledge in real time will be one of the great changes in paradigm. With with regards to something you just mentioned, we need to be aware about the fact that these are living creatures. The system that you design and use will change as you feed it and use it, and you must be aware of the fact that this knowledge is not based on a code that a civil code that is changed once every million years. This will change constantly. So whoever tells you they have a solution that is set is lying. This will evolve as you use it, and that's why it's so important to have a follow-up with somebody who knows about technologies, somebody who has expertise in this to see how to improve it, if the regulation change and the system needs to be adapted to be able to comply with the protection of data, for example. Sorry, before you were talking about keywords, etc. Now you have information available. How would you use it, or how would you recommend you use it to be able to get the best out of it? To the evaluation of profiles, how do you think that will happen? That's a great question. As you said, the technology until recently had to do with finding keywords, and sometimes you could teach a system if you were working in the investigative stage for compliance, for example, of the mention of a certain term that you know is linked to some fraud or some of those crimes. But afterwards, that gets to an analyst who has to check emails that are inconsistent, and now you can just give the emails to a system that is trained and safe, and the system itself can find the inconsistencies. So that is possible now. This is in the present. The AI can do natural language processing and can generate language and can generate a discourse with data that we give it. But from now on, the things that will happen, I'm not speaking about 20 years from now. I'm talking about next year or in 2 years. What the Gen I still lacks is the ability to make decisions. It generates text, music, images, but it still doesn't do things. And what we are developing right now, or what we're trying to develop, and what will happen for next year, is computational agents, intelligent agents. These are AIs that can act. If you need, for example, to do an investigation or profiling or some kind of risk assessment, you can say, I need to do an analysis on this particular subject. That's the prompt. And the AI will not just build a profile or a report, but it will know where to find it. For example, let's go to the trade office, and will find, the agent itself will find the papers for a particular company. They will extract all of the authorities. They know that they have to find each authorities to know their backgrounds, to do with credit, or if they have a criminal record. And each action that must be taken, each decision that must be taken, is something that the system does with less supervision from a human, accelerating time and changing the paradigm. Where you go towards the information, the paradigm is where information now comes to you and you receive it summarized, and also with the possibility of the reference to the source so that you can go and double check and supervise the functionality of it. You were speaking about several options, the ability to go and seek an external product and to get it to communicate with your own systems, the possibility of developing also a tailored system with less complexity but high impact. If you had to look for an external solution nowadays, what would you prioritize, or where would you focus to be able to ensure maximum impact? Karen? I believe from the perspective of business, I'd like to say there are canned products, so to speak, and tailored products. In 1 or 2 years maximum, the canned product will be the rule. Nobody will say, oh, I bought the new office package. No, you will actually have the AI can as part of your toolkit, and you will use it more or less with more or less intervention from you, but the general rule will be these canned products, as we say. The uh, the in-house department advantages will be in customizing the knowledge that is from that particular firm or company, or that it may be integrated with the CLM that you may have with clients. I think the competitive advantage will be in customization. On the other hand, when it comes to where to use AI, I think initially you may try to choose use cases where there is a high business value for the firm and low technical complexity, because that is a quick win. How do I present this idea to somebody who, to my CEO, to somebody who deals with the budget? I can tell them that I'm saving resources and time with a high business value and low technical or computational complexity. It'll be much cheaper than those products that require a more complex computational phase. But the difference will be in customization. I agree completely with what my colleague says. As a developer, I think legal teams will have to have their own developments to respect their own needs to do with data management and protection, knowing that canned tools always have a component that many times come out from the firm. For example, I work a lot when it comes to fiscal matters. The preservation of the fiscal secret is a need that many times doesn't allow to use canned products. So as Karen says, I think legal teams with different levels of budgets can actually afford these tools, and it's part of course, the confidentiality, data protection, the compliance with rules. To me, that's difficult to do with a tool that is canned and that does it all and nothing at the same time. We've already done half an hour, but I want to ask first something that is very personal, because all of us are victims of this process, but we're also part of this spectacular chance ahead. How would you say we should prepare individually to face this change and to get the best out of what is available for our own benefit? 1 minute from each of you, please. I would say that you have to get out of your comfort zone. We are lawyers. We were trying to get into law school to escape maths, but you must be bold. I think not in future, but even now, the law has a component of handling these type of tools and having knowledge, technical knowledge. And I think you just have to move forward and train, because it's an investment on my own career. It is not something that I do because it's in vogue or I think it's cool, but because it is part of my professional path forward. You must train, learn how to use it. I think it is a must, and it is something that is completely achievable. So you should rethink what the profession entails as lawyers. This is a bridge, as we were saying, that we have crossed, and we help others cross with us, because the law is a collective construction, and the offering of legal services is something that is built with each of the people who belong to the profession. I agree 100%, and I am optimistic. I believe that this will give us more free time so we can dedicate our time to more interesting issues beyond the law, to go home earlier as well. I believe that at some point, if I could complement what he has just said, I think another important factor when it comes to rethinking this is collaboration. AI is based on consensus and processes. You must be aware of the fact that you're not working in an isolated manner, and the adaptability to change is something that implies observing what is happening to the people who surround us, to be able to agree on a process before we make it automatic, so we don't have to reinvest once again or repeat the process. So collaboration, understanding the degree of digital maturity that your organization is in, is not something that you can do on your own. Sometimes you need somebody to help you through the process, but it is a necessary step to be able to develop technology that resists the passage of time. You can buy technology, and in the immediate future it'll work, but the one that is really worth it is the technology that will resist the passage of time. And you need to sit down and understand what you need, what the processes are that you will make automatic, and to collaborate with the rest of the interested parties individually, and to do it with the greatest flexibility possible. We hope that you have enjoyed this panel, and we thank you for this. Thank you for being here. Now we have the break. No, we'll see you in the afternoon.
Bueno, buen día.
Good morning.
Es un gusto
I'm so
compartir un
happy
rato
to
con
be
todos
here
ustedes
today.
y con quien nos acompaña para este panel.
And we're going to speak about transparency and open government with Anastasia Dosso. She is a lawyer. She's the director of privacy rights advocacy in the Agency for Access to Public Information. That you may know, we have two laws that are very important, which are the law of access to public information and the protection of personal data. Anna has also led the team who had the bill for the Data Protection Act. Thank you for being here. I wanted to begin with a question to do with the structure. I know that the agency has changed in the recent times. What is the new structure that you have, and how does it relate to what we will speak about today? The agency in 2022 changed its structure. Traditionally, it had two national directorates, one to access to public information and the other one that was protection of personal data. And in this change, we incorporated the evaluation of transparency, trying to give it a substantial role in the transparency and open government issues and generating a tripod where transparency is in having available information, it is in the way those personal data are used, and everything has to be harmonious. In some ways, and this is externally, the fact that you now have the areas better compartmentalized and you can put your energy in different areas, I think is positive, so that you can focus on transparency on one side, on data protection on the other. Do you think that that's right? That because you have divided the agency, you are able to concentrate on things? Yeah, it optimizes resources, but it is also important to think about the coordination of the three areas, and the agency as a whole presents public policies that are quality and that involve transparency, access, and protection of personal data. I wanted to ask something else, thinking strategically on your perspective as to what you should do in the short, mid, and long term. Do you have a plan for work that looks ahead about what the agency should do? We had Antorena, who has a 5-year mandate, and it was approved by resolution, a strategic plan for 5 years. It is published on the website and also in the official bulletin, so it has an institutional framework. And it establishes 4 objectives, and then it has its results, the actions, and also the indicators to be able to measure the compliance with this plan. And it's also related with the management reports that are published annually. The last one is from 2023, and you can see that in its first year this plan was complied with, but we have already developed 4 national programs on different issues: transparency, access, and protection of personal data. What particular issues do you deal with? One has to do with document and file management and the transparent access, and that's where all 3 directorates work: access, transparency, and protection of data, personal data. And there is a toolkit that has been launched to give the to show how to do this document management in a transparent way. There's 2 to do with strengthening when it comes to access and transparency with regards to the law 27275, one for companies, for example, state participation, and the other one for universities, going towards proactive transparency and trying to close the gaps that exist among different subjects. You've mentioned something that is interesting, but I think it is important to deal with the fact that because you have a strategic program that we all know as a citizenship, and there is accountability and a responsibility to show at the end of the year what you've done and what you haven't done as a public entity, that should have a lot of obligations, and it does. And at the end of the year, you present a report where you show what you have achieved in the program.
In the last program that I didn't mention was about artificial intelligence, and that one is focused on the public sector and the private sector as well. And there we are about to publish, we have developed a guideline for the use of technologies with artificial intelligence related with data, it worked. The Committee of Transparency worked on that, and Personal Data Commission, because the supply are the personal data. So it's clear what the only thing that is going to happen is that it's going to grow, and that we are going to have tools that incorporate the public and private sector. So the person using artificial intelligence has to be part of the process of that dialogue with the regulator, with the authority. Yeah, that exceeds what we are going to speak, or the debate that we have about who should be the regulator of artificial intelligence topics. Some countries say that some agency, a data protection agency, should be responsible, but well, that is not within the scope of your competence. Yeah, some data that is used is not personal data, so what you're saying, or this debate, this conversation is actually valid. Yeah, it has to be above many organizations that are regulators themselves or that are actively taking the control, but we will get there eventually. The agency, we have an artificial intelligence commission in Europe that drafted an agreement, and many organizations are part of that. The European Council is a European body that, among other things, regulates internationally data protection topics. That is something important for us. We have an agreement and convention where Argentina is part of, so everything that is related to compliance is important for us. Changing the subject and asking you about something that can be important for many of us here, and it is clear, and you can see this in your daily activities. We see more and more control and prevention obligations for companies. It is difficult to follow through, and you have more and more obligations, and perhaps you need more and more people. So thinking about the regulator, thinking about you, do you have strategies how to facilitate? Sometimes you need quality information, or have you come up with different strategies to enable the citizenship and to provide information that can help them to make decisions or to solve certain topics? Yes, we have been working in a change of the official website where information is more accessible, that is more dynamic, and we can find different tools that in the past were static, and now they have tags with international transference of personal data or information about the international agenda of the agency, because privacy is, if it's well understood, it's understood in global terms. So that role, that participation of the agency in international spaces, cooperation with other authorities, that is something that has a lot of space and facilitates for the person in a role that it's aware of and that is known. Related to this, not identical, there is something that we were speaking about when we were putting the microphones on. All the public organizations have lots of responsibilities and citizenship. Sometimes they see that some things are not complied with. I would asking you, in the case of the agency, what I wanted to ask you about active transparency. You are the regulator of many things, and it's not easy to say to an organization you are not doing the things well. So I was thinking, can you tell us what are the legal tools that you use to take to the public administration and make them comply with transparency, and how you do it, and what you can tell us about that? Last year, we launched by the Transparency Policies Offices a national portal of transparency, and it contains information of all types. Traditionally speaking, organizations would publish some kind of sheet with information, the one that they were forced by law, and it was just active transparency. But this portal goes beyond that and has what we call proactive transparency, where you create a compliance index that is accessible for all. The link, you can find it in the website with a ranking with different categories. So you have per organization and per category: budget, sworn statements, personal sworn statements, staff, hiring. So any citizen can assess what is the compliance. It's there, objective criteria was used, so there is no favoritism. They are all assessed in the same range, and that provides transparency. There is information about access and about government transparency, and something about data protection as well to encompass the three areas. Actually, I entered yesterday. The portal is quite graphic for the ones that like dashboards, has clear information about who is worse, who is the best. The agency is very well. That is good news, of course. But I wanted to ask you, you were saying we have a homogeneous features that we audit. Do you let them, or are you trained at the beginning of the year? This is what we are going to look at, and that you can give some kind of pre-notice? Or the difference between reactive and proactive? Do we want a regulator that is behind people when there is an infraction, or we want a regulator that gives tools, trains, so we don't need to get to a sanction? So that is the question. How do you manage that? And that has to do with the public-private collaboration. How do you see it? Of course, one of the things that we have into consideration with the change of structure was actually this, to approach the citizen and also to approach the legal parties. For protection of data, you have the audit with the traditional activity. When there is a violation, there is an administrative process that can end up with a sanction or not. And then this office that does something new, which is the promotion of the privacy culture. And my goal here is to be friends with the person or the company that the agency has to audit. So to provide the tools, and if my work is well done, probably we don't get to the next part of the sanction. And even if we get there, they have tools so that that this compliance is simpler. Yeah, that is something essential. Many times we need to be helping customers that are part of an audit, and it helps a lot to have tools available and to approach the regulator in a way that is thinking about compliance than infractions. So that is very much welcomed. I would like to speak about data now, and I wanted to ask you if you see, from a normative perspective, if you see trends, if you see something in Argentina that has a long-term or medium-term impact. Argentina is pioneer in the protection of personal data, and that gives us some kind of power. But we also ratified the document last year of the agreement number 8 within the framework of the European Council. We were saying before that is the first juridical element that is binding. There are 5 ratifications pending, so it's mandatory. But at the same time, we will have in Argentina, we are going to have to comply with obligations. We can perfectly say, because this agreement is not open to the signature of all the parties. You need to comply and have follow certain guidelines in the protection of data. But the Argentine legislation is in agreement, but there are other things that are related to most modern perspectives, such as a delegate for the protection of data, documented processes, and that is the trend nowadays. So within those lines, the data protection law is from 2000. One of the commitments of the administration was to create a modern project to update the data protection law. And last year entered the Congress. It is now pending for its debate, and it follows that guideline. So I think that is the path, and that is where we are heading to. 2 things about that. First, some part of that is part of the national strategy you were saying before, and one was naming Beatriz de Anchorena when she takes office as part of what she was going to develop, which was the project, and to incorporate to the Agreement 108 and the amended 108 project. And the other thing is, if you can give us a brief summary, you mentioned a few, but which are the changes that will be brought over to the data protection system that we have nowadays, the protection of the Agreement 108 or the draft that is now in the Senate? Well, not in all cases, but in those cases where certain conditions are given, such as the massive treatment of personal data or sensitive data treatment, with a delegate for the protection of data in the public sector is going to be mandatory in all the areas. Then risk assessment, modernization, and having procedures documented, so when there are security incidents that happen every day and they require modern security methods, we can apply mitigation measures, impact assessment, security notifications that are being regulated. And I would ask you this because I think these are changes that are aligned with the legislations, all the legislations in the world, but they change substantially our own system, our current system. And that is obviously a challenge for the agency implementing all these changes and thinking about your office. Do you have tools? Do you have tools or things that can help you or accompany compliance, going to compliance in general or protection, if you have tools for this specific compliance? Yes, we do. And when I speak about the draft project and the impact it has, I always try to see this as we are now putting legislation based on reality. So the legislation is now old because it doesn't show reality. And in the development of all these tools that enable us to be compliant, we worked together with the Anti-Corruption Office last year. Probably you know the READ, the Transparency and Integrity System was a module in the past. We have now a data protection module. That is a free tool with two versions. One is simulator, where the company doesn't need to register, and a module where the companies that are registered in the READ can complete the module, and that implies it shows it's like a self-examination and self-evaluation. It gives us tools that have to do with the different components, part of the module, such as risk assessment, high-level compliance, data protection, communication channels. I establish processes for the exercise of the law, which are the principles inspiring data protection that are present in the current law, but they are reloaded with modern legislation such as minimization, purpose, sessions of personal data. The important part of this module is that there is not just one question that you can answer yes or no. It leads to an infraction. So it is thought so that the company would like to be part of that, and they can use it for self-examination and see which is the gap between the legislation and where they stand. But not only towards the current legislation, of course it has parts of the current legislation, but it's also thought about getting to those international standards that are present in the Agreement 108 and in the draft project. So that is more aligned with reality. So now we don't have enough time. This was a very fast ping pong of questions and answers. I hope you enjoyed it. Thank you for your participation and for being here. So we are now going to welcome the next panel.
Good afternoon, everyone. Thank you for being here. On this panel, we're going to speak about the new challenges with the trends when it comes to money laundering and terrorism financing. Here we have Ignacio Jacobucci, who is the president of the Financial Information Unit, Maria Celeste Plec, who is the compliance director of PITSO. Then I have Delfina de las Carreras here, head of anti-money laundering from Mercado Libre, Agustín Fla, who is the compliance, fraud, and operative risk management of ICBC Argentina. Thank you for being here and for preparing this panel. We have to speak about an issue that it is very important right now, and Argentina is awaiting results of the fourth round of the Gafi evaluation, which could determine the downgrade of Argentina to the gray list, which is feared. Agustin, you were part of these evaluation teams. So what was the impact of the evolution of Gafi and their regional partners from its creation until now? First of all, thank you very much. It is a pleasure for me to be here sharing this panel and to come back here. I was a trainee here in '97. I worked with your dad, so I have many memories and I have met many of my friends here today. I had to defend the second evaluation from the Gafi. I remember it. It was June 4th, 2004, so 20 years ago. And back then, it was a complex procedure, but it was simpler in a way, because I remember that from 9 to 11, it was Brazil, which came out tops, and then Argentina, which was mine. We were lacking the law for terrorism financing, not like today where recommendations are divided. Back then it was just the 40 recommendations for technical compliance against money laundering and terrorism financing, which was called a special recommendations from 2001. And they just evaluated the technical compliance, and we did not have a penal figure for money laundering. So we did not go to the gray list, but we had to go to what was called intensified follow-up. And I remember the differences with the Brazilian is that Argentina and Brazil were sat next to each other, is that in each plenary that I had to go to, I had to gather reports from the central bank, from the WIF at that point, which was a collegiate body back then. Now it has, of course, a president and a vice president, so it's different. I had to gather everything, and every 3 months I had to go and do an exam, whilst Brazilians for 4 years could just have drinks and did not evaluate, and they just sold a law that they had from the Figueiredo dictatorship that contemplated terrorism. The law was finally approved, and that's when Argentina was able to go in again. And then I saw, as an observer of the World Bank, Argentina did not do well in 2010. Out of the 49, they just complied with 2 of the recommendations, and perhaps those who are here who are older remember what it was. The main consequence of being in a gray list in 2011 was the over-regulation on the regulatory side. So we had excessive penalties to pay, that we had inspections of obligated subjects who were centered on financial issues mainly. If they came to inspect and you didn't have a document for one of the files, that you could have problems. So now I'm going to leave Ignacio. I did not see the draft because it is confidential, but those who work on compliance and anti-money laundering are awaiting for October 1st as if it was the World Cup, because we know the consequences that it entails to be on a gray list. It's not the end of the world. That doesn't exist for me because I am an optimist. But it is a complicated issue, especially for those who go to defend our position from the public sector. But it has consequences on the private sector as well, because now the recommendations that are that have to be complied with, which are 11, highlight the collaboration between the public and the private sector, which I know that in each of the resolutions that Ignacio launched or issued, he has called us to see how it could be implemented. So I'm going to now leave my colleagues to answer about what's going to happen in October, because I didn't see the draft, but it is a complex issue, and this grew a lot, because when I went to the GAFI, it was just 5 public officials who were there at the OECD building, and today the GAFI has many more members than before. Now GAFI Lat is there because we have a lot of Latin American countries in it. So although this is an issue that people may not know about, but when I went to Paris and I defended Argentina, they would envy me for traveling. Nobody knew about it, but now everybody knows what GAFI is. Lawyers, of course, we are in the biggest firm in Argentina, are obligated subjects. So this has been really, it has expanded a lot. So you've spoken about something that is the interaction between the public and the private sector, especially when it comes to making up resolutions. How about the resolution 90 that came out this year and the possibility of an abbreviated trial for these subjects? Not because Ignacio is here, but I think it is positive. As everybody knows, we know that this was the first law that came out, the new money laundering law did not have any problems. It was sent by Fernandez, the president then, and it was sanctioned, and I understand that Ignacio was part of the commission. It was sanctioned with Milei's government without changing or any amendments. I think the law, I think it said that the Wi-Fi would depend on the the Minister of Economy. It is actually under the Justice Ministry, but one of the things it establishes beyond incorporating lawyers is that sanctions have to be dissuasive and proportionate, and they have to accumulate a series of sanctions. There are very harsh sanctions, such as multiplying, for example, the penalty that you need to pay if you don't report more, or issues that banks have to send a report of suspected activities. Now we had a timeline of 60 days, but now it's 90. But you know, it's complicated. It's banking lingo, but actually for operations with high risk, we have 60 days, where before we had 150 days to present a report. But when it comes to this particular resolution, I think it is very positive that there are many complaints that have come up for different things. There is things to do with exchange rates. They would come to the money laundering part for exchange issues that were not from my foreign exchange. Anti-money laundering has a lot of people. I work with a lot of people, 20 people and 50 in Rosario at a hub. And for many of these financial subjects, they had cases given because of minor things, and due to the background that the new WIF officers have, with new generations, with abbreviated trials and probation, there will be the chance to improve so that it is a minor penalty, and so you don't have to go to court. And also the obligation that you would have if you adhere to this is that you commit to improve it in your own system, which I think is also part of this new focus that 2002 is a focus based on risk. You have to self-evaluate independently, and I see that as positive. So for the system to actually improve instead of just speaking about the penalty. And I am sure that with Ignacio this won't happen. But having seen it in Latin America is that the normal reaction of the regulatory body is that when you go is to over-regulate, to sanction, to put penalties, to show that things are not being done, but they are being done. You have to lead interaction with the GAFI in a complicated time. What is under the Argentine law versus the GAFI demands? Next to taking the words of Agustin, his exposition, basically in Argentina we have a concept that more regulation is more control and it's more effective. And this equation is no good, actually. And this is something we should change our mindset on. GAFI today in soccer teams, it is actually looking at results. And after the restructuring of the system, it has to be reasonable and consistent with results. So more regulation, if it doesn't generate any more results, it's useless. And we know that it is costly, that when it comes to economic development and even business development, it doesn't help. And in that sense, I believe that we have to take GAFI's view. Over-regulation is also a problem. And the challenge here is how to speak about the regulatory scheme, taking that into account. First of all, the background in Argentina of a lot of regulations that were too complex and the need to generate results, and also the GAFI observations that if you over-regulate, that will also have a negative evaluation. So I think the way forward is to have an alliance between the private and the private sector, because the WIF is an entity that is central, but it's not the only one. And it doesn't know all of the infinite business models that exist. So that's where we perhaps need good feedback and good background of the obligated subject to expose what their risks inherent to that business model are and what will be their strategy to detect operations that are riskier. The focus based on risk, which is something that the WIF has tried to establish with the regulations and resolutions, is something that has to be turned into reality. It was a first step. It was a first move, but now we have to see the dynamics and to see what the risk is. And the specific question that you asked is, GAFI has many obligated subjects. Argentina has more than the ones that GAFI is pointing to in the recommendation. So we would be interested in trying to, because we don't have a lot and we are Argentina, we cannot afford to have more than we need, because in the end, that amount of the obligated subjects means more resources for supervision and eventually in the sanctioning as well. It means that we have more costs associated, and it is not the best time to take them on. And they don't actually generate more results, because in the end, if you say in the evaluation of risks, we have detected some specific sectors in Argentina that may be associated to a particular risk, then this justifies the decision and it generates results, then I would say that's reasonable. But the challenge is the balance between regulating with effectiveness not to over-regulate and to actually clarify all of the regulations, not just to do with money laundering, but with other things as well. This is the feared question. What would be the effect of Argentina going into the gray list? As everybody was saying, the process has certain confidentiality rules. I can imagine that the auditorium here knows that Argentina in general has been very reactive. In each Gafi evaluation, they have generated a change in rules. It's been a bit spasmodic without institutionality to back it up. In this case, this law came out 27739, and it came in the extra time because the visit of the Gafi evaluators was on March 26th, and this was approved on the 22nd. But we were counting days for that, and that was also a challenge to go to Congress and explain the importance of this law. Basically, if that law wasn't approved, we would not be able to reach the technical compliance. So basically, we did not go into any debate because you don't have the judicial structure minimally that Gafi asks for to evaluate the compliance. Congress facilitated this. They were good to us, and then we went with that, and we were in that particular situation. It's been now 2 first drafts. We are awaiting the last comments from the evaluating team. I am an optimist. Argentina regionally is not the black sheep. We have a lot to improve. We have a lot to work on, but regionally, I think Argentina has had results to show off, tangible things that we have done, and also some things to do with leadership. The fintech industry in Argentina is something that the world is looking at. It's not, I'm not bragging here, but generally, they want to know what we're doing. And I believe that that is also showing that Argentina is leading. The sector is committed. It has shown transparency to see what would be the optimum regulation. We have to learn a lot in regulations. We're working with all different sectors. What we do want is to get the results that the system is asking for, and so that we would have great understanding of the expectation of the WIF and to know the expectation of the private sector to be able to generate a good work environment. Very interesting. I think everybody knows this basically. Just to answer this question, the gray list is a label for to the world that says Argentines, both legal and person, are not something trustworthy when it comes to anti-money laundering. So all of the member countries say Argentina is an untrustworthy country, and so the rest of the countries, when they relate to Argentina, they have to do due diligence when it comes to controlling and taking measures to mitigate money laundering, proliferation of weapons or terrorism. So what does generate institutionally is that Argentina, when you refinance the debt or when you need a loan in the private or private sector, on the other side they will ask for more things and documents. When it comes to accounts abroad, banks will know that you're coming to a country that is not trustworthy. The due diligence is something that I have to do. It means more resources and more risks, because if for whatever reason, if that bank from another country do not comply that mitigation of risk, they will be sanctioned. They can be sanctioned. So if I have Argentine customers, for example, maybe they don't have a portfolio that is interesting enough, I am at risk of sanction, and that will mean that they're not very interested in having us as clients. And then when it comes to global integration, it also affects us because Argentina wants to go into the OECD. It's not so easy to go in there with a gray list label. So it has pretty big implications. There is a IMF report when they're talking about countries, they're doing an average. It has to be taken as a statistical analysis that says that the group of funds is lowered in these countries in 7 point P of GDP, and that would be disastrous for Argentina. So we are working, we're very committed. We're working with the National Prevention Program, which for a while, Dr. Eugenio Curia is in the head of that project, and we're doing everything we can to have the best result.
We are all promoting the WIF, I can assure you of that. Thank you very much. Ignacio, Celeste, thank you very much. One of the obligated subjects, how do you see the crypto ecosystem at local level, and how is the crypto industry after this new law? First of all, thank you for your invitation to the organizers. So to start with, I would like to speak more than money laundering, just to show you how the industry is now in the country. It is undeniable the importance of the crypto industry in our country, because there are many studies going around, but there is one chain analysis that is very important that says that we are in position number 15 of adoption. 1 out of 10 Argentines have crypto. In terms of holdings, we can say that 50% of portfolios, this is our own studies, composed by Bitcoin, 22 by stable coins, and the average, the regional average is 5%. So that means that there is a trend that we are seeing at local level where Argentines rely on crypto for everything that has to do with dollarization. They rely on an industry where there is not a money exchange problem and where the Argentine can protect from the high levels of inflation and what happens with the dollar. So this leads me to the second item in my agenda: how do we stand faced with everything that is going on with the new regulation and the GAFI? GAFI saw the importance of the sector. That's why they sat us in the table to defend everything we have been doing in terms of money laundering prevention. And faced with how the segment looks like after the regulations, I would like to say that essentially there are 3 regulations that impact us, which is the registration of the CNV and the resolution of the WIF in terms of money laundering. The most important aspects are, first, that it is what a virtual asset is defined in legal terms. Apart from money laundering, we have a legal definition in our jurisprudence that we didn't have before. So this impacts not only for compliance and money laundering prevention, but contractual topics, corporate banking topics, many things that have a legal impact. The second item is that a supplier of virtual assets is defined, what a supplier is, a legal definition of what a supplier is. That is an obligated subject. We are included as obligated subjects in the law, and they provide which are the features of those obligated subjects. And the third pillar of this new regulation is the CMV, with the competence to regulate the virtual asset providers or suppliers. So nowadays what we have is the creation of the registration, and we need a more extensive or more comprehensive regulation that have to do not only the money laundering, but the protection of financial assets users, everything that has to do with computing, security, market practices, etc. So in this sense, the CMB, as I was saying before, is the organization with competition to do this, and we have 76 virtual asset services providers and 7 legal persons registered in our registry. So we see a strong adhesion to the law. So this is obviously going to bring over a learning curve, especially in the smallest exchanges, but the impact was positive so far. And these questions is in order to understand your industry as new obligated subject. How does your work changed with inclusion of the industry in the CCOs? In terms of our company, of what happens with it, Vito has been working for 10 years in this market. It's a global company, and we were pioneers in choosing the regulated path. So there were no crypto licenses. We went to Europe to look for a crypto license, and we decided to work in countries that had this regulation in force. So we have been complying with everything that has to do with know your customer method, assessment of risk already for many, many years without prejudice of this. Obviously, when everything is more regulated in the WIF, we need to add the operating load that has to do with internal compliance program before the WIF, the presentation of the RAI, of self-examination on risk. And even though you had those incorporated, they have to be now adapted to the current legislation. And apart or beyond us, I think there is going to be a big impact on the smaller exchanges, especially with the monitoring of blockchain. We need to have investment in this sense, travel rules. That is one of the pain points of the regulation. That is something that has to be monitored, and everything that has to do with reporting, that it's an important topic as well. I like what you say, that it's transversal in terms of compliance with all the industries. When you self-impose standards and then you have the regulation, then the learning curve is softer. So it's very interesting what you say. So the important question, or the million-dollar question, how do you prepare for the GAFI audit at local level? With our users, I don't think there's going to be much change. The biggest impact probably will be in our relationship with the banking partners or partners that provide services abroad with different flows, business flows. So that's when they start to look at us and they don't trust us so much, or they start to ask about more information, more due diligence, more paperwork. And in many cases, that can even lead to closing accounts. So that can affect the operation of an obligated subject. So obviously, we will try to have as much damage control as possible. About the blanqueo, or the declaration of assets formalized. How are you dealing with that from the crypto perspective? From the crypto perspective, I celebrate that with this new law, this sector or segment was included. I think it's very important because we have a country with $270 million under the bed. So the crypto world gives us the opportunity to have a dollarized saving method without any kind of limitation in money exchange. So many people will be interested. We are prepared. We have a procedure with special reporting to help our customers to have access to this widening of their funds and their accounts. So we have a special process that will help our customers to be part of the conversation and to play the game. So going back to what Ignacio was saying, First of all, we celebrate these public-private interactions. I think that from the WIF, we were always summoned to all the working tables. All regulation was prepared as a team. And we want to have regulations that are modern, that are technological, and that do not kill innovation. Many times in these forums, we spoke about artificial intelligence and technology. So we want that these new regulations or new technologies allow us to grow as operators of the systems and as obligated subjects. Thank you very much, Celeste. Delfina, you represent a very big player in the market in terms of volume of operations. What are the main challenges that you see for the implementation, effective implementation of money laundering and anti-financing office? I think the main challenge has to do with what Celeste just mentioned, and Ignacio as well, during the last part. There are 3 stages. We go from a formal compliance of the laws and a compliance check, and the regulations were prepared that way to try or to attempt to implement normatives that are based on risk. We are doing that at the moment. That is being done. And we have a huge challenge ahead of us with new technologies. Try to have this risk-based approach with technologies. We have developers teams. The company is composed 70% of developers. So I think from the control or compliance areas, our challenge is to have compliance programs and effective money laundering programs to mitigate real risks and to understand where those risks lay, to have conversations with our players, to try to see where we stand, how our portfolios are segmented, and to exploit data, use artificial intelligence. We use many machine learning programs. We have people, our brains in the computing department thinking how they can challenge all these processes. And so our main challenge as the sector is to increase our standards and to create prevention methods. Later on, we will have to explain to the regulators when they come to audit, and the regulators, they will have themselves a challenge to understand, to audit implementing this method. So I think that is the way to go. It's interesting that you mentioned that you have in-house resources. You don't apply it only to the business, but also to the prevention area, understanding that an ecosystem based on the business is a good business. Yeah, that is a huge challenge. Everything that has to do with the company culture inside the company and education for the user, to explain a user that perhaps they don't have access to the formal financial system, and we are providing them access with financial inclusion, how to use the platform, how they need to submit a certain documentation. Well, that is quite complex. We have been busy with that already for many years. Today we see the fruits of that. But some cultural things of the company play a part as well. We are still a business. The diversification of products and services of Mercado Libre is huge. So it's a strong dynamic. We need to accompany this process, and we need to be up to the challenge. Well, you will never be bored with this. I can understand that. But I have another question about the volume of transactions of users that you manage. How do you manage risks in terms of the digital onboarding of customers? Well, the portfolio is huge. And as I was saying before, the reality is that we have a risk-based approach as a main premise, and we get creative, basically. There is a regulation that must be complied with, and that is the main, that is core for our money laundering policy. We use technology. We need to divide this question into 2. Onboarding today has already implemented for many, many years in the fintech industry and the traditional industry with the use of models, artificial intelligence, data exploitation. That is advanced, I have to say. So we trust more the models than the human capital, I have to say. Many times the level of trustability digital is higher in a model than a back office analyst can do analyzing a document with a picture. So we are making progress. Everything that has to do with the rest of the due diligence process, we need to continue working and educating our users in terms of origin of funds, to present or submit paperwork, the companies as well. We have a lot of challenges with legal entities than individuals, that they do what it takes to have their account open, and also to accompany the business and try to have these customers being loyal to the company, Mercado Libre, Mercado Pago, etc. How do you work with the different changes in the laws that are coming with the suppliers of services? We have been working with the chamber a lot and with the WIF members. They summoned us to rethink some of the resolutions and to submit working projects. And I think it is key, as Celeste said, and Ignacio as well, the public-private interaction and the understanding of the new industries, of the new businesses. I think there are a lot of new digital businesses that are appearing in Argentina, emerging or not non-emerging. We need to work in the understanding. We are doing it. We are having very productive working tables with the rest of the players in the market. And we think we're doing quite good. And we need to continue working, but that's where we are heading. And the last question: how was the in situ due diligence process of Gafi? It was very enriching. It was a very good process. I think we contributed, we had something to contribute. There was an interest. I don't know if it was some kind of concern, but questions in terms of how the fintech sector was regulated in Argentina, how efficient those programs were in the companies and in the general system, the impact in the general system. So we had the opportunity to receive the auditors in our offices. They were very interested in understanding how it worked, where the risks laid, and they were very open to understanding. And I think that they were happy, satisfied, and they were able to understand how the market was working. Other players of the market were there in that assessment, in that evaluation. So it was a very good experience, and I hope those fruits are there for all of us. It's very interesting to see how Argentina's luck depends on a public organization in charge of money laundering, but also the impression of each of the players in the private sector. So interactions is a recurring topic, and it has to be mentioned. We have a few minutes. Ignacio, I know you have a busy schedule, but we are always speaking about the prevention of money laundering, but the WIF mission is also to prevent terrorism and mass destruction guns. So we see what's happening with terrorism in Argentina, in Brazil, and the situations that are taking place. How do you see that? How do you see that risk? There is an inherent risk, and also with virtual assets, and both systems are global. So there is an inherent risk that is latent and that we need to approach. So the world, we can say, is now globalized. So we cannot take our position that physically in Argentina we do not have this risk because we are far away from this place or the other. That doesn't exist anymore. So the challenge of Argentina is to take on this reality, to commit, and to establish some guidelines. So the proliferation of massive arms that is sanctioned by the rest of the international community from the political and economic point of view. That regime, that system, what is the maneuver they have the use of digital assets. So what we see at regional level is that many times some maneuvers related to the use of digital assets are empowered by people, by groups related to North Korea. And that is the way this country obtains financing. So the challenge of all the countries, not only Argentina is busy with this challenge, and this doesn't happen in the rest of the countries. The regional challenge is to be proactive and to put the focus on that. Today is this country, this dynamic, this situation. Tomorrow can be another one, but this is the one present today. In terms of terrorism financing, we had a visit of Australis authorities. They have been mapping the risks of groups such as Hezbollah, Hamas, the use of cyber fraud, the use of campaigns that look like they are for collecting money or donations or humanitarian assistance, and they are they are masking the capturing of funds from these groups. So the main challenge is to have these risks into consideration, to have a protagonic role in showing what is the global situation is, so that the obligated subjects can have this comprehensive information, and to be proactive when looking for these type of situations. So I think that it's essential. In terms of the level of risk of financing terrorism, organized crime today is diversified. They work in cooperation. We cannot speak any longer about a criminal organization that is only related to drug trafficking. Those organizations, when they have a structural development, they start to relate or they work together with other groups. So in general, we need to have a global perspective when assessing this and a comprehensive response. I think in Argentina we need to take on this challenge as well, that the investigation agency has to work in coordination with intelligence agencies, even can be the financial agency with prosecutors, and to create a good core, a good hub for working together and facing these challenges. This happens in the United States, this happens in Spain, in Italy, in Israel. So complex threats from drug cartel and organized crime, it's combated in groups in a collective manner. So Argentina has an opportunity to get better. It's a big challenge, but I think the assessment beyond the result is what is the suitable arena to have these type of debates. I think that is what the assessment can give us. Apart from the result, obviously, it is now the time, so in Argentina we can sit down and we can speak about innovation, changes, developments that are necessary for the future. So I think that will be the best approach to have this opportunity.
I think we are in time. We do have an international entity that asks us to go into a program that will be measurable results, and that's what we have to face now, including us as lawyers, so I don't exclude myself from this new obligation. We can all go and have lunch now. Please stay for the panel afterwards, where we have Josie Thomas, the representative from the DOJ, who will speak about international cooperation when it comes to information. Now we will go to lunch. Thank you.
Bueno.
Okay, we've had the vision of the U.S. authorities, and now we have the honor of listening to our own authorities to see what are their experiences, their expectations when it comes to investigating details for corruption. We have Diego Luciani here, who is a federal prosecutor, then Ileana Schigel, who is the coordinator of crimes against public administration from Procelac, Jose Miguel Lipovsky, who is from the Attorney General's office, and Dr. Alejandro Melik, who is the head of anti-corruption office. Thank you so much for being here and for sharing your knowledge and experiences with us. I began with a puzzle of authorities, so briefly, so that the public can know what we're talking about. I'm going to begin with questions for Ileana, Jose, and Alejandro. What is the interaction between your three entities? How do you define the different interventions? Hello, thank you, first of all, for your invitation. Within the public fiscal minister, there are special prosecutor's office who give support to prosecutors, and my office has a different work to do because it's a bit different to Procelac. But our intervention is actually when the attorneys ask us for it, when the prosecutors ask for our help. What I do when it comes to corruption and crimes against the public administration, with a limitation with the PIA, with the other entity, we take some cases and they take others, especially against officers from the legislative and the judicial, and of course transnational bribing, which is also intimately related to compliance and penal liability, criminal liability. And we have the exclusive competence of the national public administration. So coordination, we also received claims from the anti-corruption office. We work with them. We've worked on particular cases, but we also do other actions that involve the Argentine government. The Procurator's office under Diego Velázquez has certain competencies where they intervene in complex areas. We intervene only for complexity and complex transnational cases. We support prosecutors from all over the country, or we initiate preliminary investigations when we see the possibility of a crime having been committed. Yes, completing on what Ileana has said, and to simplify it, according to our law, is when there are public funds involved which are administered by the decentralized entities or the government. We intervene if there are irregularities in their use, and that's where the administrative investigative office comes in, and also the Procelac, without, of course, thinking that we also have our own cases, and we also have work to do when it comes to the disciplinary area of the executive. We tell my office about these problems, and then we decide whether to intervene or not. Everything to do also with dealing with human resources in the proper way. That's where we try to determine if there's been any disciplinary problems, and sometimes there is an intimate relation between criminal causes and discipline. If a public servant abuses his power, then there will be a sanction. And that is part of what we do as well at the PIA. This office, Sergio Rodriguez is in charge of my office, and we have 3 prosecutors there, and also auxiliary prosecutors and rest of staff. Can I clarify something? something that I think is relevant because Jose is working in my office, in my prosecutor's office, and nobody understands why he's doing that because he's at the PIA. It is an important question. I wanted to explain this because Jose has been so generous with me at a point where we had to face a very big trial. We had to prepare the allegations, and it was 70 hours long, and I needed something to pick up the cases that we had. In the corruption cases that we have, we deal with organized crime, kidnappings, drug dealing, and people, and the justice has to make a decision. So very generously, Jose, without being paid, came to collaborate with me in the prosecutor's office, which was 6 months before the plea, and we kidnapped him, and he never was able to leave. I'm very happy with that. I just wanted to clarify that. Thank you for clearing that up. Alejandro, our office are organically within the Justice Ministry, but technically we are independent. We have competence in certain crimes that are against the public administration, which are defined in a commission that the country has signed. These are crimes against the government. We work on the executive and their officers, and also with national companies if they are controlled by the state. We actually collaborate and work with investigations in an independent manner. We receive claims from different parts. We begin our own investigations. We receive reports or claims from people. They may be anonymous sometimes. We may reserve their identity, and there's also an input that has to do with the obligation that public officers have if they know that a crime has been committed. This obligation that they're under is served if they come and denounce it at our office. This is the way we work, and it has a constant relation with this panel. People on this panel, with the PIA, with the PROCELAC, and sometimes that interaction is a bit informal because there is a network of exchange of information that sometimes is not exactly on paper, but it is a way to save resources that the state has, which of course are limited. So this means that sometimes we divide our work. We come in when there's a claim or when there's a complaint, and sometimes it's third parties or maybe somebody who comes forward. In the months that I've been leading the office, I have seen that many times we find out about certain investigations or events that come up in the media sometimes, and we make the decision to do preliminary investigation. And according to that, we move forward until we take them to a point where we either present them to the court or we decide that they don't have enough merit to move forward. So that is part of our activity, because we also, I don't know whether in the auditorium you have ever heard or you have seen problems with contradictions with regards to the possibility of us being the actual plaintiff in these kind of investigations. And our entity has that competency of being able to be a plaintiff if we decide to do so. It is not an arbitrary decision, but it has to do, first of all, with the principle of rationality, because resources are not unlimited. So we must determine what cases are interesting for us representing society. So there are different criteria to do with impact at institutional, social, or economic level. Generally, any case or most cases that we intervene in have an economic impact. Not all of them. I could later on talk about some that are not directly economic. For example, it wasn't during my tenure, but the example of an institutionally important case that had to do with the conduct of a former president when he violated the lockdown that we all endured during COVID. And this issue of initiating a process and presenting as plaintiffs is a decision made by our office. This competency was left to one side at some point. There was a resolution issued where it was determined that the office would be set aside from all cases where it was a plaintiff or a complainant. And we have now reviewed that position. And so we are presenting our investigations under the criteria, the umbrella of resources that I just mentioned that makes us choose with the risk, and it is the risk of ideological persecution. I am very worried about that. I want to get rid of that. The risk is always there. We're always going to have that stigma or saying we will go to this or other case due to an ideological thought. I hope this is not the case, but this is what I want to achieve, to be free of ideology in my work. So a question for Ileana, Diego, or Alejandro. You're welcome to comment. You have preliminary investigations, and we have internal investigations that are done privately. You may present them or not, but this is always contemplating the hypothetical possibility of presenting it to authorities. I don't know whether you have had to interact with this type of material. What happens with this? Is it useful? I have not had to work with this, but yes, the entity that I work with before I was nominated as a prosecutor had to go to the Penal Cassation Court. In the Skanska case, there was a possibility that companies, for example, with an internal auditor who had been recorded, the federal chamber had said this was prohibited, and the federal chamber reverted it, thinking that the activity was valid to exert the rights when it comes to disciplinary actions, because he was involved in irregularities. And a decision made in 2016, now it has a legal standing. There is a law from 2018 that allows this and that promotes internal reporting channels so that you may make a decision about it. So what I do understand is that there is legal standing, besides from jurisprudence, that guides us to give this validity. And listening to Alejandro with regards to the value of investigations, there was a case where the anti-corruption was able to be a plaintiff, and they were not only able to do that, but they convalidated an internal preliminary meeting. And if they can do that, it was a private entity with a legal standing, so they will be able to do it. I haven't done it myself, so I've spoken to some of the speakers before, because I think that's what's interesting about these events, to see how do they see, what do they do, what safeguards do they have in place. So Skanska was very, very generous back then. Now the law is more careful, and there are some things that I would not do an interview without telling the person that they're being recorded. I would be more careful with regards to the consequences entailed. But if you're involved in an investigation with possible derivations in the crimes in the law, so yours is the first information, and you have to collect it and give it to judges and prosecutors, so we may drive investigations and get to trial. So I think that is a very important thing, and the law supports it. And I think it's the experience that many of you have. That observation is very important with regards to the Chamber's generosity with regards to the Skanka case. Jose has mentioned Law 27401, which is very interesting for everybody with regards to companies. And this law, linking to this question, even establishes, sets out in Article 23, in some of its parts, when they speak about the demands of an integrity program, it mentions even the need to respect the right to a defense. So what he says is that you must have safeguards. I agree with the idea that I would not do a surreptitious or subterranean investigation of recording without consent, for example, because I would respect within the private context the right to defense of the person who will be involved or accused privately of a corruption case event, which then will be an input, as Jose has very rightly said, with two issues. On the one hand, for denunciation, and on the other hand, it has to do directly with linking it to the liability of the legal entity or person, because they may be that liability may be waived if they satisfy certain requirements that perhaps is not done in detail, but the spirit of the law, as Jose said, it is to respect the channels for denunciation and the right to a defense, and then the prosecutors will see how they take the elements that the private sector gives them, and then you have a whole spectrum of possibilities that both sides' lawyers will decide what to do with. We're here to discuss these things. There is something that I am very interested in, which I'm sure you will ask about. What happens with this law 27,401? We will now speak about a case with Ileana. And I wonder what happens in other countries. In Spain, for example. They have a similar law from 2010. In 2015, they pushed it forward even further. We have very few cases. And I think this has to do with the fact that we don't have an agenda that is anti-corruption. We haven't had an anti-corruption policy through many governments, especially the last one. The last administration has hidden corruption. We hardly ever spoke about corruption then. Now we have other authorities. Alejandro here is somebody who I've met many, many years ago. He is in a very important role. And why is it that we are demanding from companies to have integrity programs when the government doesn't? The controls in government are disastrous, and I've seen it firsthand. The system is made to go over the controls, to ignore them. So let us also speak about the independence of some entities. That everyone does it as they wish, but there is a problem. If I can choose whoever surveys me, then I have a problem. We have fundamental problems in some of these entities, and that is important. And we should ask, why have these cases linked to criminal liability of the legal person not move forward? And it is a reflection of what happens in the government. We thought it was a change of paradigm. There is a tool which is self-claim and self-denunciation. We know only of one case that became public, what could we have so that we could have more collaboration between the private and the public sector. Without talking about the case in particular, because we cannot give information, at Procelac we had to collaborate in a case which is public. It was a challenge, was begun by the prosecutor, federal prosecutor, where there was the denunciation from this company due to the internal auditing that they had carried out, respecting, of course, everything that you have mentioned. It was an internal audit where the right to defense had been respected. It wasn't an auditing that was occult or hidden. They went to the court, they presented their case using this mechanism of self-denunciation, and then the justice had to think about how to face one of these first cases for criminal liability of a company. We had prepared for this. We had done a lot of training internally and outwards to how to proceed when there is an evaluation of an integrity program or internal audit from a company, and how to seek for evidence in an independent way, which is something that had been presented. The federal prosecutor went through the whole process of agreement, of a confidentiality agreement. We reached an agreement. Right now we are under the process of reimbursing the undue amount, and that is a very important subject. So we could talk about this for a whole day, of how they can reimburse this. And with the collaboration and with the first question of how we're being coordinated, the PIA and the Procelac went to collaborate with this prosecutor in an agreement where we distributed tasks of how each of the prosecutor's office would perform. We did an investigation that was very long and harsh, and then we identified personal responsibilities. Everything that had to do with the company's liabilities went on one way, and individual responsibilities went to the other, and that's where we are right now. There is now a denunciation of those people, and we got evidence, and the prosecution has worked, and we have managed to see what their responsibilities were. Up until now, and there's a long way to go, but this has shown why there aren't more cases, why there is no, the phenomenon of, from the public sphere, there may be help from both sectors and collaboration to face these corruption subjects that are so complicated, and they may be carried out in a serious way. The federal prosecutor really had to work hard, as well as the other two prosecutors' offices that took part, determining liabilities, responsibilities, and what was the role of the company and what was the role through this investigation and the self-denunciation. Right now, there is no problems when it comes to the internal auditing process. There's been no challenges about that. I think the greatest challenge that we face and that we have discussed many times is the change of paradigm, the change of culture. As a country, we're still not used to thinking from the perspective of compliance in this connection between the private and the public spheres, to reach agreements with prosecutors' offices, and to be able to move forward with a collaboration agreement and a serious criminal investigation to determine whose responsibility this was. This also encroached upon public officers to see who was involved in government. There's been a very interesting way to be able to test what that collaboration may be like. Minimally, can you speak about that dialogue between the public and the private? Just about the dynamics of it. It is a constant dialogue, and this is a challenge to be able to sit down, to have a dialogue, and to get to these proceedings where the evidence will have to be validated through other channels. And in the prosecutor's office, we have to do our own investigations and to get probatory elements that perhaps were not within the internal audit. It was very successful, actually. We were able to carry it out. Very interesting. Diego, the new federal criminal code, can it encourage these type of agreements, these type of self-denunciations? Yes. We see in jurisdictions where the new code is being implemented that the cases are faster. The prosecutor moves forward in the investigation, and I think this is very good for the system. This is also good to keep the judge in a more impartial position. The only thing that I can see is that we need to be very careful with the resources that we have as prosecutor's office. We don't actually have a lot of resources. They're pretty scarce, and you have to administer them. And when we have complex cases such as corruptions, sometimes we have to think of who will work on a complex case and who will keep the other cases. So this may give a different dynamic, and all countries in the region have gone through this. But we must be very careful about the resources that we have for the public ministry to be able to face all of the cases that are coming our way, because we don't have a lot of resources when compared to the judicial power. We have this problem with the lack of resources. A vision that I have when it comes to my personal experience, at the PIA sometimes we work in tendering processes, and when it comes to the government tendering something. And what you're interested in is how does the compliance works according to the decree 1069 from 2018. As a company to tender, you must say that there is a system of integrity that is effective. The decree says effective. So the first thing you would think about it is not just an obligation, it is an obligation for results. If there was a case, the case was not it wasn't effective, the system. Today I heard the Chilean lawyer who was saying the focus of Chile when they say the system is adequate beyond what happened, and reading the law nowadays and outside the spontaneous reporting system, any case of corruption, wherever you see it. I printed here a tender from last year. The company signs a checklist, does a risk evaluation. Does it have a code of ethics? Does it permanently review it? Is there a channel for denunciation? I know that the president of the company say yes, yes, yes. They just check it. If there is a case of corruption after this, I know here that I have the elements that allow me to accuse the entity for whatever happened. So at least what I am seeing is that take it seriously when you check yes, 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 because this may have consequences in future. And it is a law that has no cases so far, but when we have the first one, we will have a true avalanche. So that is something that will happen within the framework of a new code, with the prosecutors pushing for it. This means that we will take it to judges and judges will see it. We have to have resources. We have to have the means to do it. We're thinking about it and we are analyzing it. And that is something that we need to take into account in this interaction. That is exactly the purpose of these events, to see what you are thinking. So thank you. So, okay, that's clear. Alejandro, how about the RIT here, the RIT? I'm going to advertise my own office. It is a platform that was developed by our office. Before that, I'd like to agree with Diego with regards to the lack of resources, in this case in the public ministry, where I would say most percentage of work will fall on that particular office. But this new system that is being implemented region by region in our country, I am convinced that it will generate less corruption. It is a more agile system. It is led by the public ministry. So the judge, as Diego said, and as we all know, will just be the guarantor. That's something I wanted to mention. And with regards to the RITE, this registry for integrity is a platform that our office has developed. It is a tool that is dynamic, that is voluntary, and that has a use. It is a sort of self-evaluation that companies who register can do, which is intimately linked to the private and the public when it comes to advantages. Why do I say this? On the one hand, we have listened of a change and talked about a change of paradigm. This is true. This is the position of the Anti-Corruption Office. I'm not going to say something new, saying that corruption is an evil that is endemic, that generates poverty, generates deaths. It takes away our rights. So I am convinced that the public sector must do more when it comes to integrity and transparency. And they must do more because it is the way that they can demand this from the private sector. I am convinced that the public administration, in this case our office, or the state, the government, cannot tell the private sector to do something they're not doing. We are the authority of this public ethics law, and we're also the entity that leads on transparency. So in this framework, we are drafting a national strategy of integrity to respect standards that are international. It's been mentioned today already, the intent of our country to change through the OECD. Ignacio Jacobucci has been here speaking about that. But these are necessary situations to position the country once again in a different stance to the one we're in. That is what we're dealing with. And we are now busy drafting with other entities, government entities, a national integrity strategy. And among the items of this strategy, we are also preoccupied in bringing awareness to all public officers when it comes to integrity. I'm talking about awareness because it is analogous to what the private sector must achieve and is doing, to bring awareness to integrity, to ethics, which is one of the headlines of here is compliance. What does compliance mean? It means to do your duty, to respect rules. In the private sector, it is about what the private sector and the companies must do. And some people may say that it generates expenses, but it adds value actually, because it is common sense. companies, when they deal with the government, they have to have an integrity program. This is in the law of responsibility of the criminal responsibility or liability, and it establishes the way that the person, the legal person, may be exempt of that responsibility if they cover those rules of that program. There are demands that are minimal, requirements that are minimal, and in the law sets out a lot of extra requirements that they have to do with the financial capacity and the activity that that particular company deals with. So there are many points in common between what's private and what's public. The RICTI is a register where you can monitor whether the companies that work with the government are registered. It is a sort of checklist that, as Jose said, must be filled dutifully, because otherwise it's like when we fill in forms and say I accept, and then when you see the small print, you can see that there are problems. And on the other hand, in the case of Securitas that Ileana was mentioning, and in the case to do with this law 27401, this registry helps the government to determine whether the company has actually complied with the requirements of the integrity program. And from the perspective of the private sector, I believe these are all advantages. I am advertising our platform.
How do you say, BTN? I think that it's a better reputation for the private to be part of this registry. It's voluntary, but we invite companies to join. There are different modules, and the main module is an integrity module. Written has 4 modules: integrity, due diligence, that even coincides with some of the preventive measures that the law mentions in its Article 24. There is a gender module and personal data protection module that is very sensitive and very necessary, where we establish how companies that have this flow of data that are private are protected when these data are being used. So I invite you all to register. Thank you very much, Alejandro. So that now that you're here, and another question that doesn't have to do with the legal field, complex research, what can you tell us about the non-technical aspects of the research of complex criminal organizations that have economic and political power? Well, what Alejandro just said, corruption is one of the main evils after our country and after our region. It is one of the big attacks against our constitution and to human rights. And I speak about this in a book that was published in Spain. In a country where there are over 50% of poverty, the state appropriation of assets or corrupt business people affects human rights, of course, clearly. So justice has a very important role to prevent corruption or to stop corruption. To stop corruption and not to be the warrantors of impunity. So that's why the justice system needs to act fast, efficiently. They cannot speculate with this type of crimes. There is no speculation that is valid. There has to be exemplary sentences for this type of issues, firm sentences, that the corrupt person goes to prison if that is what is being dictated, and obviously to recover the state property. And this is not easy to do when you face power, when power is in the power. This is not something easy, because power is going to resist. And why is it going to resist? Because they want to keep these privileges. And they will use all the possible media or means. They have subtle means. A lawyer, lobbyist lawyer that approaches the offices of the judges, of the prosecutors, saying, can you imagine that, or is this possible? Or more brutal moments where there are threats, coercion. But when all these means fail, because the prosecutor is firm and applies the law, it is firm, being independent, and they hold on to the Constitution, to the facts, to the evidence, then another pressure means will come. There are colonized means by the political power that attack prosecutors and judges, and we have seen this with the previous government, the previous administration. And I can tell you, I am evidence of that. We faced a series of obstacles with the complexity of the case to analyze all this documentation, where this file speaks to you page after page, and there were other derivatives fails with 6 people in an office. Jose knows about this very well. This is titanic work. 113 hearing, hours and hours of debate, but also other type of obstacles appear. A few days before starting this litigation, a secretary from the court requests the file because they need to solve something, a complaint, resource, or an office, anti-corruption office, that is not the one where Alejandro is now working. Alejandro is an amazing person. Stop being the complainer, the complaint party for anti-corruption, and they become the defendant one more time. A financial information unit that becomes another defense, and that's why we have the problems we have today. We are one step almost inside the gray list. They are asking for a total and irrational dismissal. We have a president, we have ministers, public officials attacking prosecutors with undue allegations without respecting the independence of the different branches of power. So this is what we had to deal with. Many times alone with our team, a team that is very ethical, hardworking, with high values. So it even happened to us that a president, 2 days after my allegations, said to us and hit us where it hurts, Nisman committed suicide. I hope that this other person does not. My children were watching TV at that moment. That's why justice has to be up to the challenge. That's why us, when we speak in our allegations, and we speak, of course, to the judges, we speak, of course, to the accused parties, but also to the entire society. And to speak to the society, we need to do it in layman terms. We need to lower the jargon, the legal jargon, so that everybody knows what we are talking about. To put a chart on screen to show how it works, to shed a light, to show corruption, all type of irregularities in the bidding strategies where none of the principles related to transparency, competition were respected. Same patterns, same things to benefit a partner or a business person. And in this clear language or layman terms, when I say the business person, when this administration of 12 years old ended and had 14,000 hectares in his name, you're going to say, well, what does it mean? But if I tell you it has 20 cities of Buenos Aires instead of 14,000 hectares, well, things change, and then you understand, and then you put value. So, to conclude, it is so important what we said before about corruption or justice. 3 words that sums it all. And there is no doubt that justice has a very fundamental role to stop corruption. Thank you very much. Thank you for your participation. I want to add something else. I am sharing this panel with 3 members of the ministry, the public ministry, so I'm very honored. And I want to be brief. I understand the demands from the citizenship, high demands to combat or to fight against corruption. There are only a few number of cases that end up in litigation. But on one side, I would like to make a list of some names of people that were brought to justice, and not after it was the administration, the outgoing administration. We have here 3 public officials that were related to processes that brought people to justice, a former president or a former vice president. It is true that it doesn't have a firm sentence, but it was brought over and is facing litigation. There was also a vice president, a male vice president, that was condemned and detained, many secretaries. So it's not nice to give you a name. The list is long. The list is long with names that you are very much aware of. A minister that also had to do with death. That's where corruption and death. I am speaking about the train situation, because sometimes we get distracted. Does corruption mean death? Yeah, it also means less education, less routes, less infrastructure. But really, the very valuable task from the public ministry that is independent, that has been very bold and very brave with these procedures, these 3 members of this panel that represent the public ministry that leads public action in representation or on behalf of all of us. So I wanted to really highlight this. I think this is needed. We need to have a change in paradigm, and they represent that very well, not now, but also before. Thank you very much.
Ana López Espinar, ¿cómo estás?
Muy bien, gracias.
Bueno, muchas gracias. Contanos cómo ves el evento hasta ahora, ¿qué te parece?
Bueno, como todos los años, súper interesante, siempre congrega a muchos colegas súper conocidos y Marval siempre nos recibe tan bien. Los paneles son siempre muy dinámicos, muy interesantes y es como el evento del año para todos los que estamos en la profesión, así que muy contenta de estar acá.
Bueno, y vos vas a estar acompañándonos en nuestro último panel, así que comentanos un poco, ¿querés adelantarnos un poquitito de qué es lo que vas a estar comentando?
Sí, no quiero spoilear el tema porque están por acá mis compañeros de panel y estaría muy mal, pero sí vamos a estar hablando del rol de los forenses en las auditorías externas. Ustedes saben que la auditoría externa tiene un rol muy distinto, el objetivo de las auditorías externas es muy distinto de lo que tiene un equipo forense. y sin embargo en ciertas ocasiones son necesarios ese involucramiento de los especialistas en forensic en las auditorías. Así que bueno, vamos a estar conversando de por qué, cuándo, de qué manera nos involucramos y bueno, por qué valor agrega estos equipos que suenan medio raros, estos forenses, a la auditoría tradicional que es la auditoría de los estados financieros.
Bueno, muchísimas gracias y esperamos escucharte. Gracias. Gracias. Bueno, estamos acá con Rosario Civit del equipo de marketing de Marval. ¿Cómo estás, Rosario?
Hola, Clary, muy bien, la verdad, muy contentas con cómo viene saliendo todo el evento, ya estamos sobre el final, pero la verdad muy orgullosos de cómo viene todo.
¿Querés contarnos tus impresiones hasta ahora? ¿Cómo viste los paneles? ¿Cómo viste el evento en general en esta 7ª edición?
Bueno, es la 7ª edición, entonces siempre es un desafío lograr mejorar entre la edición anterior y la nueva, digamos. Y en ese sentido creo que mejoramos bastante, lo veo muy bien al evento. Tuvimos un récord de convocatoria presencial, así que nunca tuvimos tantos asistentes presenciales al evento, estamos muy contentos por eso también. Eso enriquece mucho los espacios de networking, que es parte de por qué hacemos este evento. Y speakers de altísima calidad, la verdad que todos con charlas interesantísimas y muy contentos con cómo viene saliendo.
Bueno, muy bien, nos quedan 2 paneles más. ¿Cuáles son tus expectativas para este cierre del evento?
Bueno, yo desde la organización espero que todos lo disfruten sobre todo. Me parece que venimos dejando la vara muy alta con todos los paneles que ya tuvimos hasta el momento, con todos los speakers, con todos los temas que se trataron que son recontra de actualidad. Y creo que mis expectativas es que no bajemos de ahí, digamos, y no tengo dudas de que tampoco lo vamos a hacer.
Bueno, muchísimas gracias. Bueno, ya estamos por cerrar, nos quedan 2 paneles más. Vamos a estar hablando sobre los desafíos de compliance en las diferentes industrias y nuestro último panel va a estar hablando sobre el rol de los equipos forenses en el compliance. Así que, bueno, esperamos que puedan disfrutar de estos últimos 2 paneles que quedan y que haya podido disfrutar de... Buenas tardes, estamos acá con Diego Luciani, uno de nuestros speakers que ha participado en nuestro último panel. ¿Cómo estás, Diego?
Muy bien, muy cómodo, la verdad que un placer estar acá con ustedes, les agradezco la invitación y los felicito por esta gran iniciativa, ¿no? Esto de estar capacitando al sector público y al sector privado, de alguna manera, en temas tan sensibles como es el tema de la corrupción, en donde todos tenemos que ser parte para solucionar este problema que viene hace tanto tiempo, ¿no? Un gran flagelo que nuestro país lo padece hace muchísimo tiempo.
Bien, te quería consultar cómo viste la conferencia hasta ahora, qué te parecieron los paneles, o si pudiste escuchar algún otro.
Mira, yo llegué muy justo para el panel, pero el panel que tuvimos nosotros fue realmente un placer, ¿no? El doctor Alejandro Melik es una persona sumamente preparada, con mucha experiencia, hoy está a cargo de la OA, José Podorski, que como dije en el panel trabaja conmigo, ha tenido enorme generosidad, en momentos que yo necesitaba en la Fiscalía una mano, generosamente él estuvo al lado mío y por supuesto Eliana también, una referente de la Procelac, ¿no? Creo que el panel estuvo muy bien armado, muy bien estructurado y con las preguntas de Andrés también espectaculares, muy bien él en cada una de esas intervenciones.
Bien, y por último, ¿hay algo que te gustaría destacar, algún highlight de tu panel?
Bueno, yo voy a destacar lo que siempre digo, ¿no? Que la justicia tiene un rol dirimente en materia de corrupción y esto de repetirlo hasta el cansancio, ¿no? Esto es corrupción o justicia y esto tiene que quedar bien en claro, o es una cosa o es la otra. Y la justicia acá tiene que actuar para impedir los hechos de corrupción y que los corruptos tengan sus sanciones, ¿no? Conforme los fines preventivos generales de la ley, ¿no? Y mandar un mensaje muy claro a la sociedad.
Bueno, muchísimas gracias. Gracias.
Okay, good afternoon. Thank you for being here. I hope you have enjoyed the panel so far, and I hope that you will accompany us on the next panel. Now you will hear about people who were perhaps in positions that are very similar to the ones you have in your own firms. And the idea is for you to discuss best practices and experiences. Karina Kusik, she's a compliance officer in Mercado Abierto Electrónico. Pablo Gibot, Legal Affairs and Compliance Manager in Compañía Mega. And Gustavo Regner is the Compliance and Ethics Director at LATAM for Bristol Myers Squibb. First of all, I'd like to ask each of them to tell us a bit about the industry that they work in and what are the specific features of the companies you work with. And I think that will help us see different perspectives and differences. Thank you very much for having me here. At the summit, I am the compliance officer in Mercado Abierto Electrónico, MAE, which is one of the 3 markets that exist in Argentina where we trade foreign currency and bonds. And the main activity is to provide a platform where you can trade these type of titles and values through the intervention of brokers that have. This is done through an electronic platform that has different systems such as MyClear. I believe they're all technological softwares, and we have different types of financial products. MAE is the primary market, concentrates over 98% of the negotiation of public and private tenderings of bonds and securities and other instruments such as fixed income, futures, and foreign currency. For us, that is vital. MAE is the only market that is free in Argentina. And this also means that we have to pay attention to many regulations, especially when it's to do with their main regulators, which is the NCB, the National Commission for Securities, and the Central Bank. And that summarizes our industry. Gustavo, how about you? I am the director for LATAM for Bristol Myers Squibb. They are the sixth biggest pharma in the world. We specialize in rare diseases, and we are leaders when it comes to cancer, Alzheimer, schizophrenia, psoriasis, etc. Therefore, we are a biopharma company. We do research, we invest in R&D, we develop new products, we do biotechnological products, and therefore the relationship with doctors is daily, the R&D, and also with the government. We have a lot of technology which is new and disruptive, and we bring it in, and sometimes the regulator does not understand it, so we must have conversations with them, with the regulators, and therefore it is a very sensitive issue. And ethics and compliance is vital. Bristol has a separation between compliance and the legal department, so we are a team that work back to back, each with a specific focus and that complements each other. Pablo? Good afternoon, everybody. Thank you for inviting me. I am so happy to be here at Marval. I worked here for many years, 14 years I worked for this firm. So I am in charge of legal affairs and compliance manager for Compañía Mega, which is in the oil and gas industry in midstream specifically, and we have as shareholders YPF, Dow Chemical, and Petrobras. We founded it in 2001, and nowadays it adds a lot of value to energy, because what we do is we make viable all the natural gas from Vaca Muerta. We have a separator plant in there, one in Bahía Blanca, and then a duct to transport the liquids. So the value that Mega Energy does, besides from us selling the liquids, is to condition the gas that is produced at Vaca Muerta, and we process around 40% of the production of natural gas from there. So in our case, I am in charge of legal affairs and compliance, which was defined with our integrity program. And if you'd like, later on, we can continue speaking about the perspectives of the pros and cons. Let us know what your experience is, the pros and cons of having both roles under you. When we defined this, we agreed also with the three shareholders, international companies that are much bigger than ours. Our company has very important business and operations, but the best way to delineate and to define our program and the role of compliance was to keep both roles together. So I think as benefits is we're very close to operations and business, to the staff areas, and that allows us to get to really know how businesses are run. And from that point of view, we can guide and support more directly various areas. And it also would allow us, if we had to analyze any kind of suspicious situation, we could understand much more where to look, how things work. We are in the world of engineers, surrounded by engineers. It's 7 lawyers and a myriad of engineers. And it's much better for us to be so close by to them, because we understood, of course, understanding the machinery, the equipment, the devices. We learned a lot from the oil and gas sector, and I am becoming slowly an engineer. I think that's a good thing. Karina, let us know how you deal with the sector, we also have a legal and compliance sector. They are together, but the compliance area has a certain autonomy with regards to the legal area. In my case, for example, I don't deal with legal, I only do compliance, but of course I am close enough to be part of a directorate where we constantly interact with the legal as well. In my personal opinion, I believe there is not just a single way to have it, whether they should be separate or together, because I think that depends largely on the industry, on the company, on the size, and the financial resources available, the exposure to risk, whether it's worth having a separate department or not. And I believe in some cases it is good because it gives more hierarchy to the compliance sector, and it accentuates the company that the commitment that the company has with compliance. But it doesn't necessarily mean that if it is separate, it has more commitment. So there's not a single response. It depends. And setting up an integrity program depends on the specific company, the expectations, the risks, and their capabilities. And you have the same reporting scheme within the company, right? Compliance reports directly to the ethics community or to the board. So it is different to others. So as I was saying, it is a hybrid system. Please tell us. Maya has a lot of special features. How do you see the assessment and the risk assessment in such a complex area? It is very complex because our shareholders are financial entities, so they are very much regulated entities. Our market has the special feature of the specialty. It has a lot of specific regulations that are applied as a market, and this is not a daily use. That is not that you work with other colleagues and you know what these are. In Argentina, there's 4 markets. There are specific regulations, and this means that it is difficult to do benchmarking or sectorial meetings or even to look at models to compare because we're very few. So this is the challenge of being creative and being rigorous about regulations. And on the other hand, the Latin American market is, of course, fluctuating and is you have to be flexible to adapt to new standards, to new regulations, and to crisis. So innovation has to be a must. Yes, we have to pay attention to that. And of course, as part of being regulated, it is also a company that is out into the stock market, so it has, of course, obligations, and it has regulations because it is in the stock market. And the other challenge is that although we're so highly regulated, we shouldn't forget the regulation compliance and the integrity program. We must pay attention to the fact that we base our work on values, and we must focus on our anti-corruption policy because we are in touch a lot of the time with the public sector, with the government. And in fact, last year, we had an upgrade of our code of conduct and ethics, and we focused on the relationship with the public sector, with the policy for gifts, conflict of interest, and with things to do with the market, insider trading, confidentiality, etc. And the last challenge is the technology. We are a technological platform. We operate in that market, and therefore we have the challenge of always having to adapt compliance to the new technologies, to the new products, and trying to always be from ground zero, to be sat at the tables where there are new technologies or new businesses, so that we are not the stopper at the end of the product and say yes or no once it's finished, but to be a business partner to be there from the very beginning so that we can be a real business partner and not somebody who is an obstacle.
What you were saying is very interesting, this obligation to innovate, like you have to do it, there's no other way. And we spoke about this with Gustavo in the pharmaceutical industry that has a lot of tradition in compliance and very much developed in everything that has to do with compliance. So how can you innovate when it looks like everything is there, everything is thought over and tried and tested? Yeah, that's how we always did it. The winning team, we don't innovate, we don't touch. Well, everything changes and everything is modified, and there comes a moment when you say, if you want to win, you need to take risk. So it's very easy from our role to say just no. It gives you a lot of power to say, no, I'm not going to do it. And why? Well, because compliance didn't let me do it. So you start innovating from compliance, legal. We are always like, well, take risks, and it should be the opposite. But sometimes you need to create situations where how do you innovate? How do you incorporate technology? How do you make your work easier? I heard today, well, we want to leave early today. Well, that I cannot do. But we are always working in trying to do things differently, not only from the science perspective, but also new medicines, new products, but also how we can speed up and how we can make things more agile. Perhaps you have someone in your family that suffers from a serious illness and you want that medicine to be a good one and not just to take that medicine because the doctor is getting something out of it, because a percentage goes to him or to her. There are many series in Netflix about this. You probably know them. But from compliance, how can you make such a diverse force can receive a training that is innovative, an awareness that is different? 3 years ago, this wouldn't have been possible. We would have been remote, wearing a mask. It's not that COVID is not there anymore, but we try or we learned how to live with it. How can you do with a company where compliance is tradition that you don't get relaxed? So we start to innovate and incorporate technology, incorporate artificial intelligence. We start to work monitoring in real time. Some of us use Concur, tools that monitor payments live, and they monitor live interactions with doctors, and they tell us in real time what's going on. Not to punish them, but to correct in real time and focus on that. It's only a few of us for Latin American team. We are a small team. And how do we leverage this technology? So we launched our first digital human. She's called Clarita. Clarita, which means in Spanish transparency. She was born in 2020 as a cartoon. She was the one sending the newsletter. And last year she became a video. And this year, July 8th, she was transformed into our first digital human. First for training, in a few months she will be used for interaction where you can pose questions. And then later on you will be able to have a dialogue, even a meeting with Clarita that is connected to an internal ChatGPT. But what is rich for us is that it gets multiplied, this demand gets multiplied, and it creates a lot of data for us. So it allows us to work in real time with a lot of data. Corruption is the thing that we need to communicate, and people are speaking about something else. So that is captured in real time by our digital human. In terms of trainings, and you were telling us about the complexity of how these two plants work, connected by a pipeline in Omega company. How, apart from these two plants and these offices in the center, how can you provide or distribute training into different facilities with different population as well? Well, we have the 2 plants. We have a pumping station in Rio Negro, and then we have our central office in Buenos Aires. So we have 4 sites, and as you said before, within the elements of the integrity program, they are all very important. The active, direct involvement of the executive committee, everything that has to do with communication. But I think to have a training, a quality training, is fundamental. That's why we have a challenge where we need to make sure we are able to access all the spaces that the company has, because we have rotating shifts, and we need to see how we can make sure that our operators in the control area, these are technological plants that are being operated with control systems. We have 24 valves. All is managed by a monitor, and people that have to be very attentive about what the alarm is saying or showing. So we make sure that the training is going to be good enough so that the operators in the control office are receiving that training. Because even though in the control area it's closed and isolated, it's difficult that they get to corruption activities. Well, we need also to be transparent and comply with this protocol. So it's a challenge. We go 3-4 days. We need to have meetings, and we also have our contractors there, and we are very happy and satisfied that this is well received, that we are able to do it, to have trainings where there is a lot of participation, involvement. We also make it entertaining, so people, that is dynamic and people can participate. And I think we are getting very good results. We are going to add another digital tool, such as e-learning, to complement this. And you will have your own Clarita available. That is a complement, as Gustavo was saying, concerning our focus, trying to control these risks that we have identified in terms of corruption that are related to all management, licenses, series of permits, national permits, provincial permits, environmental permits. We don't have artificial intelligence, but perhaps in the future. So we try to work with training and the collaborators that have direct collaboration with public officials. And we actively participate from the legal department. And we are participating directly in everything that has to do with the administration of this proceeding. And that allows us to be near all negotiations, and this is a tool, artisan tool, that is effective in order to take care of these risks. And speaking about risk and the different areas where you work, where you are involved, Karina, your company has a special feature. These are shareholders that are regulated and customers that are very much regulated. But I wanted to ask you about the interaction with this shareholder package. Indeed, that's how exactly how you say it. So our standards are quite high in terms of compliance. Beyond the local standards and everything that I said before, many of our shareholders, they have parent companies abroad. So for us, it's very important to be up to date with the different international practices and certain regulations applied internationally in the entire company. We work very hard to be aligned with these policies. The risk areas, cybersecurity, apart from compliance and legal, complying with IOSCO standards, and to be sure about what is our role as third parties in shareholders, customers, even when we receive their own due diligence, to give a good and efficient answer and to make sure that we comply with everything they need from us. And in line with what we were saying about which are the tools that can help us for this type of control that is huge. This year, we worked strongly in the company with a tool in a platform to help with this compliance, normative compliance control. This is a tool that plans all the compliance tasks of the year, of all the areas of the company, with different entries to control when this standard expires, what is applied, when, what is the evidence that is needed to verify its execution, different things that allow us to see where we stand in real time and what happens with each of the areas. It's very interactive, and it provides you with reports. And how did we build it? This was a co-build project with different areas of the company. We exchanged the standards that we knew, which were the ones that would be applied to this case, how they could credit compliance. So many areas participated from this, even improving the tool that we proposed from compliance, to be present in all the areas of the company and to be transversal, to have conversations, to participate from this makes that any tool, any compliance tool has a better or a stronger basis that is well taken by the company. If we go back to the conversation of Gustavo this morning with the panelists about artificial intelligence, you took this option of developing your own tool, exactly, that tool, even though we are now testing another tool, and that was also mentioned in the artificial intelligence panel, the HR assistant, because we are self-regulated and also regulated, quite harshly regulated from external parties. To find sometimes certain internal regulations is difficult. So we are trying this tool that was mentioned in the other panel that allows you to summarize and to find in very long texts a very quick response about where the standard is with a link to that document. So you can click on that link and verify that the answer was correct. So we have something, it's not Clarita, but we have something with artificial intelligence. Clarita is Karina in this case. Gustavo, you use other artificial intelligence tools apart from Clarita? Yes, we have 3 different ones. One, our own tools, monitoring tools. Others that allow us or gives us assistance. We are subject not only in Argentina, we don't have we are not forced to show transparency. So we need to do in 3 countries. A year and a half ago, that would be done manually, 120, 130 man hours of a person uploading hours. Nowadays, we can do it with just 1 click in a few seconds. So we can release time and use that time in other things. The more time you have, more things to do you can find. But we also have other tools where we work for the external work with or related to artificial intelligence, which is essays. There are some things that you need to work on. That's why we have a secure environment for artificial intelligence, where probably most of you know that when you use ChatGPT, that is public. So you cannot work with ChatGPT in an open sea. I mean, we have an internal ChatGPT where you can work with these topics. You can play with it with different subjects, and it is used by different teams. So you need to work and see what they are using, what they are not using, in order to determine that what you are getting to a result in a study that is feasible, that is solid, that is accurate and trustable, and it's not that someone used ChatGPT and just wrote something down. And so you need to have tools in place to verify this.
These are great examples of the use of the possibilities of AI. We began to speak about shareholders, and I'd like to speak to you, Pablo, about the interaction with three shareholders that belong to different countries. Two of them have government stake, and these are companies that are very big, such as YPF, Dow, and Petrobras. When we delineated this program, we worked in a coordinated manner and very close to the compliance areas of the three shareholders. This was in 2018. And that allowed us to seek consensus and to define together the way in which we considered it would be better for the company. And as Karina was saying, we defined that the area of legal and compliance to be under the same head due to magnitude, our size, but that doesn't mean that we did not have to go through a process that was very deep to try and align our program to integrity with our shareholders. This was something that actually worked well. We managed to get to a consensus so that then we could get the approval of our board at the end of 2018. And then that dynamic just continued, and every time we reinforce our program with new initiatives, we coordinate it in the same way so that we can also get the board to approve them. And in parallel, we have direct contact with the representatives of the compliance area of the three shareholders. In some cases, there are periodical meetings in YPF, for example, and we talk about initiatives, we discuss good practices, and we check how all companies are doing. And in the case of the other shareholders, periodically we get an assessment so that we can indicate how the program is doing. We welcome suggestions, and we see whether we can reach an agreement, and this is something that we keep trying and working at. It is a challenge, of course, because you have two public sector companies, and you have also a lot of interaction with the public sector, so it is difficult. You have to cover all of the alternatives. With each important move that the company makes, you have to review those issues every time. And now, coming back to pharma, Gustavo, can you please tell us what is the role of data privacy in your sector? How do you manage to go through all of those challenges, also to do with compliance? I'd have to call Antonella because we work shoulder to shoulder in the legal issues, but mainly the main goal that we have is that patients work and they have a relationship with their doctors. Our teams are not in contact with patients, and we want them to do that, whether it's research centers, clinics, or the patient to be treated. And so that the decision of a treatment is in the hands of the doctor. Of course, as a pharma company, I have to know who is being treated. I have to give you the best product possible so that you as a doctor can make the best decision. You can actually, as a doctor, you have to make the decision that is independent. So you don't have to give me any data for that. So we work on anonymity constantly. We try to have very strong tools when it comes to not just data protection, but sensitive data protection. And it's not just the fact that there may be a famous patient or anybody, any of us are trusting your details to a doctor. So when you give this data to the doctor, it may be leaked, and it's very sensitive information. So we work a lot in bringing awareness to protecting data. Do not use WhatsApp for this. Do not use this channel for information. It doesn't matter. We try to educate. So our team, I mean, doctors, researchers, they say, oh, yes, I know, it has to be anonymous. And that is your job as well, right? To actually teach and bring awareness. Yes, we work very, very much on that from the compliance and legal area. Yes, we have a BCF team, which is internal control within the company. It is a tripod that we do with the legal area. Legal is to do with the external, with the outer world. Compliance is inward, and BCF, or internal control, is permanently controlling. It's not an audit, but it helps us to make our programs solid. So it is, they do permanent, ongoing monitoring. So with that feedback, I go and train my teams, and legal helps us with everything to do with the regulatory framework externally. So you can cover your tracks constantly. Yes. And Karina, MAE means that you have risk for cyber attacks, insider trading, confidentiality issues. How do you handle those risks? Do you do that from compliance and legal area, or what? When it comes to do with cybersecurity, this is a company that operates on platforms, so it is vital for any company. Cybersecurity is vital, and for us, it is even more so. There is a specific area for cybersecurity where we work and we focus on the confidentiality, integrity, and availability of assets of the company. And we work on the top 3 of risks in these issues, which is cyber attacks, malware problems, then things to do with users, user behavior, as data leaks, for example, and then specifically we work in phishing or fraud to do with identity. So we work with cybersecurity when it comes to reviewing policies. We always talk about policies and rules. Then we about culture, and they have a very strong policy in cybersecurity to do with training, both hybrid, in-person, and constant awareness campaigns that are very interesting. Some are synchronous and some are asynchronous. For example, with exercises, what happens if I get such and such email? There is a scoring system, and that's something we work on as well. Everything to do with market issues such as confidentiality or insider trading is specifically dealt with in the code of conduct and ethics of the company, and it is reinforced with the training sessions that we have yearly on this issue. And the other thing that I'd like to mention is we do not have Clarita, but we do work a lot. I would love to have Clarita. I think that would be fantastic to take information on what is being needed and what people are asking, so to see where to focus. I love that. In our case, what we did is to separate the line for claims or complaints, and we opened a consultation line to do prevention and to see what people don't understand, what's worrying them, what makes them hesitant, and we do it a bit more manual to get information from that and to be very present. In my case, the role is to be present, to interact with all of the areas, to generate trust, presence, and so people may come to you and consult. It is an open door compliance policy. But it depends on the size of the company, the industry that you're working in. You can't always do that. You can't always do that. This works for us and it gives us a lot of information that we need. But I believe that the elements of what compliance used to be, anti-corruption compliance, which is to do with policies, training, education, and now they keep coming to us to apply this on different areas. The most important part is in the hands of another discipline, but the methodology, the design of the policies, procedures, and education is still us. It is replicated in different areas. That's why I think compliance cross-cuts everything, because it is an ethics perspective with a format that is repeatable for all areas. It crisscrosses everything, and we can see this in our clients in general. Pablo, I wanted to ask you something. I don't know what adjective to use. I wanted to ask you, what did you consider to be the element of an integrity program that is the most efficacious? And now, after having had this conversation with the prosecutors, I don't know whether to say adequate or effective. That I share what Karina has said. I think there are a lot of elements that are very important, but the way that we perform our role, we have to be a strategic ally to all areas, especially new business areas, commercial areas, and operational areas as well. And I think that seems easy, but it's hard. We need to be seen as someone they can trust, that they can ask advice from, and that we can support. And as Karina was saying before, I try to get all of the members of my team to show that closeness, and I do the same. I go through the plants, people know me, the staff knows me, and that enables more closeness. And I have meetings face to face so that I can have direct contact and generate relationships, and then they can call me or they can write to me, and I believe that makes it so that everything flows better and that we can all have this culture of ethics expand and disseminate, and we can do it much better as allies and not be kind of a policeman to be feared. I think we are a bit late, but I wanted to ask you something, Gustavo. How do you manage the asymmetries in compliance in the industry? Which is an easy question, isn't it? This is something that we see in most industries. We see it when we see a shareholder that has a very aggressive authority over them and the others who don't. That is part of the conversation.
That is part of the conversation in the pharma world, why they can do it and why we cannot do it. So always the argument, we don't like comparisons. We believe and we know what we have to do and how to do it. There are asymmetries, and it is true that we are subject to different regulations. And many times it's not the same for all of us, but we are convinced that what we want to do it, and we are not complaining about this symmetry. So the idea is, I want to do things right. We want to do things right. So there is, we want to work with the perspective that we are doing this because we are convinced that this is the best way to do it. People from compliance hear this and they say, okay, that's our work, but it's essential that people can listen to their leaders, to their referents, to say these things. So if I go and I give a training In our case, the CEO says, just do it because compliance says you should do it, then you're like, well, okay, let's do it and get over with it. But if someone says, no, this is the way we're going to work, because we are convinced this is the best possible way, then the message is different, because there is no comparison. There are other families, each family is a world in itself. In our home, this is how we do things because this is the best way for us. Very clear. Thank you very much. Thank you, the three of you. It has been a pleasure to share these differences and similarities with you and see how you approach this topic. Thank you again.
Thank you for being here. And now we have three professionals here that are very well known and who are very well known to us. And they work on forensic teams. That's what they lead. They are the most important forensic teams in Argentina. We have Ana López Espinar, who is the lead in head partner in forensics KPMG. Leandro Dores, partner in Forensic and Integrity Services, EY Argentina, and Andrés Sebastián Sarcuno, Forensics Data Analytics Leader in Deloitte. In general, we know and we always go to services of forensic teams when it comes to investigations, and we have a context that is pretty well defined of what their role entail in investigations. But we wanted to complement that with and give one more step and to get to know what is the role of forensic teams in internal auditing. And that's why we have these three experts to talk about this particular issue. I will begin now with you. First question, why do we need a forensics team in a routine auditing? Is it necessary even if there's no suspicion of fraud?
And thank you. We are so brave to be sitting here till the end of this event. And the role of forensic experts has sense even if there is not an instance of suspicion. And more times, the international signatures of audits have established necessary procedures, the involvement of forensic experts, especially because they have a different perspective. You know that external audits, what they want is to understand the reasonability, that numbers reflect truly or reasonably the economic reality. But the forensic is after other things. It's like the forensic police that is looking for the hair under the fingers. Well, that is something different. It's a different perspective. The involvement of the forensic experts in a routine procedure is to add a complementary perspective and understand other types of risk that perhaps the audit team normally wouldn't detect. They should perhaps detect them, but not necessarily is part of their task. It is not part of an external audit, this requirement of detect all the types of fraud that can exist. So their perspective is in this specific topic of fraud, it's more narrowed. So the perspective of a forensic expert goes beyond that and identify risks that perhaps the external audit team did not find, and by detecting this risk, you can see if there are indicators that could suggest that there are irregularities. It's like what happens with all kind of things. If you don't know, if you don't see it, then you don't know it exists. So to be able to focus, to zoom in different types of risks related to that business, then that would allow you to find situations that are happening and the auditor was not able to detect. Leandro, in these procedures, what is the specific role of the forensic team? We need to take on, if we have an audit, this auditor needs to, as part of his or her routine, will have the support of a forensic team. Good afternoon. Thank you for your invitation. And in our profession, as the profession of external audits is evolving, we have different types of regulators, different types of customers, but more and more times there is a multidiscipline team that challenges the traditional systems so that the working team can give answer to risks. So from planning, when you see how the audit is going to take place, the forensic expert tries to identify new risks and anti-corruption standards that are not accountable, but that potentially they expose the company more. The auditor is after reasonability of the numbers, and they are always focusing on the material or substantive differences. Sometimes something doesn't look substantive, but can have an effect on reputation, on the business, that is more extensive than just a normal or small fraud, or traditional fraud. Also with technology, trying to find which are the daily entries, and what happens with invoicing to third parties, risky third parties, etc. So international firms are now risk-oriented, and within these risks, obviously, you have integrity fraud and other issues that can affect the reputation of the company. So it is something that is already part of the menu of good practices. Andres, I wanted to ask you, and you were saying you agreed with a suitable investigation in this type of procedures and audits. Good afternoon. Again, thank you for your invitation. The reality is that what happens here is that timing is important. I'm not going to lie. It's not the ideal moment in the process, but this is not a suitable research. First, you can have a latent risk that something continues to happen, the situation in the organization, that the root cause of this was not found, and it depends on the organization. If it's a public company and you have later on some kind of claim, or that the organization didn't do all their best efforts to investigate the situation or to identify the root cause and implement a remediation plan. Without a proper investigation, then you cannot find the original cause, and any remediation plan is going to be limited to what was found, but not what you could not find. And it happens that you have this small blanket or this friction between how long or how much you need to investigate and what is the final end result, that is to issue the financial statement. So at the end of the day, if you don't submit in due time and form the financial statements, you need to have a reasonable cost for that. So that's very important that it happens. Of course. And from the company's point of view, what you were saying before, it looks like this is part of the protocol or good practices from the audit. But the company itself, which are the main or the first actions that should be taken when faced with the auditor if you have a fraud suspicion. If the company suspects that something is going on, probably that will have an impact on the financial statements. You don't include in the financial statements the payment of bribes, obviously, so you need to see how the numbers have been affected or adapted. So the company needs to tell the external auditors that there is suspicion. So first, some preliminary measures to understand what is the claim. If they can find something or they can say, well, something is going on here, first they need to understand what does this entail, which people, preliminary investigation. So start an internal process to determine either by hiring experts or an internal team to see what this complaint is about, what is the problem, what is the fact, what people can be involved, which processes are involved. Companies try to determine the initial scope, the initial understanding before letting the external auditor know. When they have this external claim that can have an impact on the financial statements, and the best practice is to notify the external auditors so the external auditors do not suspect that information is being hidden. Obviously, what you're going to be communicated is we have this suspicion, we don't know if we have evidence for this, if it's just a suspicion. We are going to work very responsibly with this. We are going to take all the actions needed, and then to communicate which are those actions that are going to be taken, to hire a law firm or a forensic team or internal sources, and what happens with internal resources to lead this investigation, this research. Sometimes the objectivity or independence can be questioned, but there are companies that they have internal teams that perform investigations. So they need to explain to the external auditors which are the actions that the company is going to undertake to validate this claim. So that is the initial approach. Later on, if this complaint is based on facts or evidence, then periodic updates to the external auditor are going to be given so that they are aware that the progress is being made in this process. So from the auditor's point of view, it's like I have these suspicions, we agree the course of action, and then a report about the follow-up of this investigation. The more information or the more open you are to the external auditors, then it will be better for you. So the external auditors, they don't suspect that you are hiding information. So you're saying, I have a suspicion, I'm going to be busy with it, and then to go deep into that process. Also considering not losing the privilege or the client lawyer benefit. And it is lost somehow because the external auditors, they don't have this obligation of confidentiality. So we need to be very aware of that, how much you give away. And the next step in this process is the shadow investigation. And Leandro, I wanted to ask you if you can tell us what it is about and what does it entail. When you are on the other side of the company, as Anna was saying, suspects or there is allegations or they need to go deep into a process, you have time, you have expirations, time against you, and as if the customer is regulated, then you have more protocols that you need to comply, internal policies, etc. But the auditor, as we were saying before, has a different profile. So specialists, what they try to do is not to redo an investigation, so because we are speaking about the independence of the auditor, where the auditor cannot lead an investigation, but they rely on the forensic teams. When we need to calculate, for example, taxes, we rely on our accountant. The analysis of how the company starts to perform or starts to initiate actions. You try to evaluate transparency, communication, the attitude of the team. If it's an independent team, that will depend on if we are investigating allegations or fraud. And that will have a different answer if it's someone from the purchase department or a third party. So there is a protocol to be followed. The idea is to monitor, to always test what is the scope of the research, of the investigation, which is the period covered. So it's the counterparty of the internal investigation team from the auditor side, trying to obtain evidence that things within the financial statements are what they are and there are no contingencies. So there we have a protocol to follow concerning confidentiality and how information was protected, how we can access information, and even in some cases, depending on the depth of the problem, is to improve some of the processes. If an external auditor is auditing the company, they try to delegate or they apply some criteria. So this is a process. In a company, special process, internal investigation, depending on the different characteristics, you will have a different profile of auditor. And the auditor will take into consideration the effects on the financial statements with the help of the forensic party to see if the original cause was correctly investigated or if it should be communicated to a regulator because there was a breach of the data. So how was the answer of the company and their advisors? So normally this is done by the audit committee, which is independent, or a similar body, depending on the structure of the company. Andres, let's now move to another topic. We touched on that this morning. What are the challenges posed by artificial intelligence with these different roles of the forensic teams within the framework of the audit, research, shadow investigation? The first challenge is that normally we need to analyze electronic documentation, and if we have reviewers to see what happens, there is a batch of 100,000 documents that must be reviewed with a senior accountant of all the documents. The challenge we will have today is that a new level of review is created, zero-level review, and this first classification, this first labeling is by generative line. And the error rate will be probably lower than if you have a first level review. So the challenge ahead of us is that didn't happen. We don't have a case in the United States Justice that these are supported and they are saying that the generation of production is from a zero level review or the use of generative artificial intelligence. But that will be a challenge. What in the past we only relied on human beings, now we rely on artificial intelligence. So what are they going to review? A reviewer of what was labeled by the artificial intelligence, or even a previous step, how the prompt was designed for the classification of those documents. So as researchers, first we need to see how it was designed, because perhaps an organization comes and says from the shadow point of view, show me the prompt. The shadow would ask you the prompt. Or which LLM did you use? Perhaps it was not the language model that was necessary. Perhaps it was a previous version, or the prompt was not well done. So, as it happens with every technology, technology is a tool, and depending on the input, what you get. So if it's massive, then the problem is exponential. Or it's not that a researcher or a person that did not understand well how to create the prompt. It's not human error anymore. So one of the challenges will be that. And then search for terms. The keywords world will be left behind, and we will have context questions. Please search if there are conversations about corruption, or if someone asks for a bribe. And then we will trust the interpretation of how the generative AI searches for this. In the past, we used to search for similar terms, and that could be explained, but this we cannot explain because artificial intelligence, the machine learning, cannot be explained. It's a black box. It's not that you can invest time, $1 million, you cannot explain how this was created. And data, when you have research and you say, I can have this investigation without getting involved with the private life of this person. And then you would put in the report the terms that you read, and you showed the judge that you didn't use any word that had to do with the personal or private life, that it was only for research. But with this black box, that would be very difficult to explain. You also can ask that all documents concerning private information are highlighted. So the challenge ahead of us is what is the level of confidence, of trust that we are going to assign to that. That with all this information available that we have, one we cannot use because the generative artificial intelligence said that it had private information and it couldn't be used. So if part of that information is the amount of buildings or apartments that were built by this person that were for the wife and separate from the apartments of the company, well, that is private information as well. But that information also has to do with the research, because funds were being destined, funds for private enjoyment, funds that were for company only. But that will be discarded as private information, and it's not going to ask you. That will be left out and you will miss it. So that is the complexity. And the audit standards, they require going back, require testing. So which are going to be the tests or the samples to obtain the facts that we want to prove, but also this theory of finding a black swan in the sample. Which is the sample we're going to use? Because the external auditor needs to have an environment where there is not much alignment. That was my next question. Do we have standards that certify or force people to justify or to say that they have been using artificial intelligence? Yes. The researcher, if it's an external team that is hired for this investigation, will come up with a working plan for that research, and they're going to define which are the procedures, if it's interviews, reading documentation, looking at documents, analyzing accountability, or if they read emails. So that working plan will be the one received by the shadow investigation team working for the external auditor, because the eyes of the forensic expert will look at everything that is have to be looked at. Otherwise, we wouldn't be in a place to see if the financial statements are being audited correctly. So the idea is to validate that the scope of the investigating team is the suitable one. And if there are things that are not well documented, then it's going to be difficult that the person in charge of the shadow investigation can validate that everything that had to be reviewed was reviewed, because the investigator is doing things that the shadow investigator shouldn't do. But as investigators, we need to declare that we used mechanical or artificial intelligence. But when the auditor receives that, it's going to say, how can I make sure that this is comprehensive, sufficient, and complete according to the parameters of our audit standards, international, American, global standards, Argentinian ones. So all that, together with what Anna was saying, is essential. It's one of the keys, the involvement of the external auditor with specialists that are the counterparty of the internal investigation by the company.
Because as usual, depends on the client, on what you're investigating, what's in play. You could have different ways to focus it, but with an independent role, I cannot tell the client this is the way you should investigate, but I can talk about what my suspicions are as an external auditor. If you're analyzing purchases or acquisitions, for example, who are the people who belong to that structure? What was their power to decide and evaluate? Whoever is doing the shadow investigation to validate whether those people who could have known due to the flow of the process, whether they read the emails, for example, they are the custodians, which is what we call them, to analyze those communications. That type of things, as Leandro is saying, must be understood by the person who carries out the shadow investigation, because otherwise it is a limited process. The external auditor always seeks out experts so that they can actually have an opinion on the balances. And the same way that they find a legal expert to evaluate assets or to check on losses on some assets, this is the same. The external auditor must seek support. The shadow one has to validate the investigation of the organization. And of course, the organization wants to make it as short as possible, because what has been discovered is the tip of the iceberg of a very big problem, and perhaps even the general manager doesn't want an in-depth audit. So that's why it's so important to have an auditing committee and to have autonomy of that investigative team so that it can be carried out adequately. Anna, if during this investigation you see that there has been some kind of derivation or a defect in the procedure, what do you do then, usually? When you do the shadow investigation, from my position as shadow, the forensic expert who's doing this, if they detect that certain custodians have not been included, or that there is information that hasn't been analyzed, or there are procedures that were more limited than they should have been, what you do is periodically meetings with the auditing team, with the forensics teams who's doing the shadow investigation, with the team that is actually investigating for the client. You do either meetings weekly or every 2 weeks, so that to see that the scope is not sufficient and will have to comply is to include within the scope whatever they weren't including so far. And in general, and this is a question for all of you, based on your experience, what are the keys for success and the most common mistakes that you've seen in procedures? Andres? I've mentioned it before. The first mistake is to do with opportunity, of the fact that you may think that this is too small and it's not being analyzed properly for balances or for SOX matrix, and you don't add other scopes, and you tell the information to the external auditors too late. Timing is always crucial. because we want everything, they want everything to be resolved in 7 days, but it's impossible. Because when it is a public company, you have to present balances at a certain date. And this, of course, triggers many risk indicators, because if you haven't told that to the stock market, for example, ombudsman, we know that these investigations, the preservation of evidence, and there are certain concepts there that are very difficult to do it in a retroactive way. So, and the other one is the fact that when you begin an investigation internally with IT, and they say, oh, there's nothing in the emails, for example, and then the investigator, the specialist, begins late, and then the external audit is also delayed. So everybody is delayed, and that means that evidence may be compromised, information may be leaked. Governance is a very important issue as well, and especially the multidisciplinary analysis. If you don't put legal experts there or an external auditor you have to do the risk assessment. This is whether this is a local entity that is regulating how to preserve the value of the shareholders. Beyond what we today have been speaking about an investigative team, how do you think the investigative teams will evolve with ChatGPT? Do you have perspectives about it? What do you foresee? I can begin. I think we'll have more time to actually find what is being done wrong, because sometimes the main challenge for us is that we are in a universe full of data, and what's rich about an investigation is not in that particular data that is unstructured. It may be a chat, it may be a PDF, it may be a website or a conversation which has been recorded, it could be an image. And before, investigators were always, in investigation, we cannot do it for a year. They call us and they want it to be very quick. I think we're all cognizant of that. So that works against us, because before we could do it. It's not that we can do it faster today. But now in 5 minutes you can actually execute something on Python that before it used to take 8 hours. For example, image recognition. So I think we will be more effective and faster. So anybody who wants to commit a crime should be very careful, because we have a tool that, of course, can be used by perpetrators as well. This is a tool that, depending on the input, could be very good or very bad. So teams must be trained in being able to identify that as well. Everything that is to do with fake images, videos, documentation, and fake parts. You can use it for good or evil. But that is once you've gone through the instance of having this risk that we have nowadays, that the initial revision may leave some material that is relevant outside the scope of the investigation. I think tomorrow it'll be more a procedure that will be best organized. I think this is something that is being used already. It will be one more protocol. Now, for example, when we talk about the scope or the structure, this will be part of this process. We have the power to process a lot of structured information much faster than before. So it's not just that our teams will be smaller, but that the fact that now we will have the time available to carry an investigation all the way through. So to put more value to what the human being, we can focus more. And on the other hand, the regulators will also start to use protocols with this. So everything will be much more standardized and more controlled, especially because we use that, but many companies, for example, if you do ChatGPT, it goes on the cloud. So Gen AI has certain protocols, even in companies. We were listening before to people talking about avatars. There is a whole way to do it. The compliance is part of that. AI is an object for compliance because it needs to be regulated and you have to comply with the rules that are established for that particular issue. And it is also a tool for compliance. I think the challenge, the difference with software programs that where you write the rules and you have a language and you will get to a result, what you do is a prompt with orders. You can be very specialized to edit the answer. But what you're doing is actually limiting it. So there is a margin for the response to always be different. We try to make it as similar as possible, but who wrote that prompt? So companies, of course, they have AI at the prompts to teach teams to use the right prompts as well. But in our cases, we begin to use it to find labels, for example. And when it comes to revision, it has accelerated by 90%. There's still a long way to go, but if you apply it, you have accelerated by 90%. You have reduced by 90% the time you used to use to go through the documents. It depends on who understands the tools and how to use them, and the risk of limiting perhaps what you're going to see, because I think investigative teams are always training. Before it used to be this, and before it used to be another technology. All the time we must be up to date, because whoever is going to commit fraud is always learned before us how to use these tools. And it is not a minor issue, because if this can mean the reduction of the cost of investigations, then I don't know whether cost, but yes, when it comes to timelines, I think in time it will have an effect on costs as well, because we may speak about compliance that will be more expeditious, more active, more dynamic, and with the possibility of seeing more things, because as Andres was saying, everything to do with videos, conversations, not unstructured information, where we have a lot. The structured one belongs to a database with very easy to reach parameters, but the rest that was not so easy to process through these technologies, you may encompass them. Before it used to be very, very hard to do. So we will have more information to analyze it faster with many information sources that used to be much more difficult. And we'll also have a better safety situation context. And it will generate more accessibility, and it will be more incorporated to the culture of companies, this investigation. Because today, if you tell a company to investigate, they say no. Yeah, there's still a ways to go. It's true. No. Accessibility is one of the big changes here. This has broken the barrier of the language of programming. We need to learn a language to do it, and that's what it's broken. I don't think we have processed it completely, but that barrier is now broken of what could be done before, but you had a barrier. You had to have the language, and that's been broken now. And from then on, you have somebody who can respond your question. You just have to know what the right question is. It's been my pleasure to have you here. Thank you. It's been very interesting, both subjects that we have spoken about. I think it's new and interesting. Thank you so much for your availability, for being here, and for everything you have shared with us. It's been great. Before everyone leaves, we wanted to do the closing remarks and thank everyone who's been here, especially those who are here still. Thank you so much for participating in this event and for helping us make this a success. Thank you to everyone who is online and who followed us live on LinkedIn. And I want to highlight the generosity of all of the speakers who were here with us today to share their knowledge and who took their time to prepare and to think about each of the panels that we proposed. We are overwhelmed with their generosity and so thankful. So just that, to thank everyone, speakers, the people who are here and the people who are online, who have helped us to make this event a true success. And I hope you have learned something new to learn. I take from this the fact that compliance is not just clicking on a box. The formal part is done. We've seen when it came to money laundering with compliance, and in the panel to do with Argentine authorities spoke. We want a compliance program that gives us results, which is effective, which can be measured, and I am taking that particular idea and concept with me. I thank everyone as well. It's been a pleasure to share this with everyone. If you weren't here, it wouldn't be worth it, and I think it's part of the positive part. The panelists have told us that they were speaking to some of the audience as well. I think this is very enriching, and we believe that it is one of the things that we can take as lessons learned, as a takeaway, and what we had planned for this meeting. And we try to do it every year with different experts and professionals and authorities to share their experiences and to tell us their expectations and their wishes for the next year, for the following year. So thank you so much. I hope you've made the most of it, and I hope it's useful. And we await you to welcome you in the next one. Please fill in the survey so that we know what subjects to go for next year.